Good morning and welcome. My name is Terrence Carter, and I'm the managing partner of Carter's. It's my great pleasure to be a co host for today's annual Charity and Not for Profit Law webinar, which continues the tradition of serving the charity and not for profit sector, including the broader faith community, through seminars and webinars every year since 1994, making this our 31st year. A big hello and thank you to our loyal repeat attendees, as well as to first-time registrants, including many of you from across Canada. It's a privilege to have more than 1,190 of you join us today, as we know that your time is valuable. I'm very happy to have Sipa Bani, a partner and our trademark IP counsel from our Ottawa office, join me today as a co-host.
Thank you, Terry. I'm delighted to be able to join today. I'd like to take a moment to acknowledge the traditional territory of the Anishinaabe people, including the Ojibwe and the Ottawa of the Three Fires Confederacy, from where Terry and others are located in Orangeville. For those speakers and myself in our Ottawa office, we acknowledge the traditional unceded territory of the Algonquin and Anishinaabe people. For those in the Toronto area, we acknowledge the traditional territory of many nations, including the Mississaugas of the Credit and the Chippewa, amongst others. Now, in the past, many of you will remember when we were hosting in-person seminars, we were able to sing "O Canada" together. But given the overwhelming preference for a webinar format, that is no longer possible. However, that should not stop us from celebrating how fortunate we are to live in Canada as a true North, strong and free. As we just recognized Remembrance Day, we remember those who have given their lives for our country and for the thousands of men and women in the military and our police forces across Canada who keep us safe every day. Thank you.
Today's webinar is intended to provide practical information on current legal issues for charities and not-for-profits to help mitigate against unnecessary exposure to legal liability. There are 9 great topics being presented today by a lineup of very qualified speakers that charities and not-for-profits will no doubt find relevant and helpful. Please refer to the short bios of each speaker and the link to event resources, as introductions of speakers will be kept to a bare minimum. It's important to point out that the information provided during this webinar does not constitute legal advice, and as such, attendees are encouraged to seek assistance from their own legal counsel before making decisions based upon information provided during the webinar. Please feel free to subscribe to our charity and NFP update, published 10 times a year through our websites at carters.ca. It's a great way to keep current on changes in the law. Please note that an on-demand replay of the webinar will be made available this year for all registrants later tomorrow or on Monday.
I'd just like to take a moment to thank some of our special guests that will be speaking today. We have the Honourable Ratna Omidvar, retired senator from Ontario and former deputy chair of the Special Senate Committee on the Charitable Sector. As well, we have Bruce MacDonald, president and CEO of Imagine Canada.
On behalf of the team at Carter's, we'd like to thank our sponsors who have made it possible for us to have Event Stream Productions assist us with today's webinar. Thank you to our gold sponsors, Adam and Miles, LLP, Chartered Professional Accountants, Robertson Hall Insurance, and Thomson Reuters. Thank you as well to our silver sponsors, LexisNexis and Beacon Endowment Solutions. Information about our sponsors is included with our resource materials, and we would encourage you to review their materials and visit their websites to learn more about what they have to offer. Please also see the links for sector resources in the event resource button for the CAGP, the 4Cs, Imagine Canada, LexisNexis Canada, and the Ontario Nonprofit Network.
Now, this is quite important. You'll want to stick around until the very end of the webinar because there will be a raffle, and we have a few things up for grabs. So first, from Thomson Reuters, we have 1 copy of the Corporate and Practice Manual for Charitable and Not-for-Profit Corporations, which is a 4-volume set. And then from LexisNexis, we have 1 copy of the 2025 Charities, Legislation and Commentary, 1 copy of the Management of Not-for-Profit and Charitable Organizations in Canada, 5th edition, and 1 copy of my favorite book, The Branding and Copyright for Charities and Not-for-Profit Organizations, 3rd edition. We also have a gift card that was generated from the 4Cs for $100 for the bookstore.
Okay, so what can I expect with the flow of the webinar today, Sipa?
Terry, the presentations today are very fast moving at 20 minutes each, except for the two fireside chat speakers who'll have about 30 minutes respectively. The lawyers will answer questions at the end of the webinar. The PowerPoints are very intentionally content rich and they're intended to be useful takeaway resource tools for the future.
So the big question, Sipa, is will there be enough time for me to tell a few jokes?
Well, Terry, lucky for you, you'll have 5 minutes after the 10-minute mark of the coffee break to tell your jokes, provided, of course, that you choose some funny ones for a change.
Okay, Sipa, I will do my very best. Thank you for that. Well, we're ahead of schedule. We're going to get started now, and looking forward to a great time together. And our first presentation is dealing with gift acceptance policies and donor agreements and integrated approach. And we have two of our partners that are going to be presenting on that. Jackie Dempster from our Orangeville office, as well as Ryan Prendergast. Both of them spend all of their time working with charities in their full-time practice. So over to you, Jackie and Ryan.
Great. Well, thanks very much, Terry and Sepal. So as Terry said, Jackie and I are really excited to be back and to present to you today on an evergreen topic of gift acceptance policies and donor agreements. So, we'll see the theme that you hope we walk away from today is that they're really two wheels of the same cart. So oftentimes, we're called to, help draft or to review either gift acceptance policies or donor agreements. And normally we often ask, can we see your policy? Can we see donor agreements? Because they really need to speak to each other and work together from that angle. So hopefully that's a lesson you can take away today. Okay, so here's a brief overview of the presentation. As Sepal said, a lot of these slides today are content rich, and so you'll find a bonanza of different legal tips and suggestions throughout there. So again, you can take these away. You'll see that the slides for this presentation in particular can be a bit dense in some places. So Jackie and I aren't going to be spending a lot of time going through those, but making that available to you at a very high level this morning. So why did I say that the topic of gift acceptance policies and gift agreements are sort of evergreen? Well, the reality for many charities is that they need to keep the lights on and they need to, have a robust planned giving program to in order to get money into the charity and to keep doing the important work that they're doing. So having a gift acceptance policy that works together with gift agreements can help support that approach. And you'll see they work together sort of hand in glove and allow the charity to come from a position of strength, really, when it comes to donors coming towards the charity, wanting to know what they can do, how they can give. And it leads to, having the charity to be conscientious and having thought out about what its planned giving program is going to look like, the types of things they're going to receive, and how they want to handle certain gifts. So just on the topic of gift acceptance policies only, we'll just talk about what it is and why that's important. So, the main thing about having a gift acceptance policy is that it helps donors to say yes. So it can help facilitate, attractive donations to the organization, and it can also help the charity to say no. So those are two important aspects of wanting to have a gift acceptance policy from a fundraising perspective. And then they also can serve a very important compliance perspective as well. As you'll see later in the slides, getting it wrong with accepting gifts and trying to receipt those types of gifts can lead to severe consequences for the charity. And that might include allegations of breach of trust against the board. It might include monetary penalties from CRA if there's any issues with receipts that are issued for gifts. So having a gift acceptance policy that sets out those procedures can help avoid all those consequences. It can also help to manage donor relations by making sure that everyone's playing with the same rules. So when everyone comes to the table to want to talk about large gifts to the organization, the donors know what rules or what boundaries the charity wants to have, and the charity knows itself what boundaries it wants to have for the donations that it's going to receive or things like that. So you can avoid misunderstandings happening down the road. What do you mean? I thought the building was going to be named after my dad forever. things like that. So it can deal with those concerns happening. And also from a more practical standpoint, from an operational and management point of view, it helps to make sure that you're avoiding case-by-case subjective scenarios where, people are going back and saying, oh, what did we do in this instance? The donor coming back and saying, hey, I want what I did, 5 years ago. Why can't I do the same thing? That kind of thing. So having an updated policy can help to address those concerns and can also help with training and making sure that staff are familiar with those boundaries as well. So when it comes to developing a gift acceptance policy, there's a number of suggestions here. You need to set out, the roadmap to know where you're wanting to go. So it's important to make sure that, you have a plan or a goal for the plan giving program, and also talking to legal counsel about whether it's going to work or not, and also talking to staff and the people that are handling this day to day to make sure that their input's being received so that, on a practical standpoint, the plan giving program and the gift acceptance policy reflects what the charity actually does on the ground, as opposed to having something that's very high level and may not actually fit or work for the charity. Other considerations that we'll talk about briefly are, whether or not a gift acceptance policy should also deal with sponsorship. When sponsorship can differ from a gift and how that can be treated. For some donations that come with strings, it can sometimes be hard to know where that gift ends and where the sponsorship begins. So that's an important thing to consider as well. And just a few other things here. So when plotting out that roadmap, you want to know operationally on the ground what's going to be important, but also the legal risks that need to be managed through a gift acceptance policy as well. And that can include making sure that if you're accepting gifts to do certain things that have restrictions, that the charity is actually able to do those, when they receive them and later on, and whether or not they're complying with various provincial and federal rules that deal with that. Very quickly, just in terms of developing a written policy, you want to make sure it's written down as opposed to just something that staff remember or talk about with each other. And one quick tip here is to just make sure that when developing a gift acceptance policy, we often recommend two versions. So one is an internal one that staff can look at and use as sort of a how-to when dealing with gift acceptance, and another one that can be posted on the website or made available to donors that's more of a user-friendly, high-level version of that policy. Lastly, on this slide, you'll just note that there's a few things that the gift acceptance policy should be coordinated with, such as, a sponsorship policy, as I said before, or naming policies if those are in place as well. So now I'm going to turn it over to Jackie to talk about the other hand-in-glove topic of donor agreements.
Excellent. Thank you, Ryan. Good morning, everyone. I'd like to speak to you about what donor agreements and why they're important. We'll start with first principles as to what is a gift. A gift at law, as said on the slide, is a voluntary transfer of property to another party that's made gratuitously and without consideration. In order to be voluntary, a gift, the donor must have the intention to make the gift and the capacity to do so. There has to be a transfer of the property over to the intended recipient with evidence of their acceptance. And there can't be any consideration back to the donor for making the gift. This could result in too much control by the donor, and that might defeat or negate the gift, which we want to avoid. Let's talk now about gift agreements. Now, legally, you're not required to have a gift agreement, but it's a very good idea to show evidence of a gratuitous transfer of property, receipt of that property by the recipient charity. It's also extremely important to have a gift agreement to help evidence what the terms of the gift are. We may remember it now when we make the gift, but if it's a long-standing gift, 10 years from now, people might not remember. Having that written agreement in place will help all parties understand what was agreed on at the outset. If I can move to the next slide, Ryan. Let's talk a little bit now about restrictions. There's unrestricted gifts and restricted gifts. If I write a check for $100 to a charity and I don't put any restrictions on that, that's an unrestricted gift. It can be used by the charity to fulfill their charitable purposes without any restrictions imposed by myself. They can decide how to apply that gift as long as it falls within one of their charitable purposes. The board can also decide whether to spend the gift right away. They could invest it and just use the income, or they could internally restrict my unrestricted gift for a specific purpose within the charity. Alternatively, when I write my $100 check, if we just go back, Ryan, for a second, I can impose some restrictions on how the charity is to use the gift. I may require them to use it for a scholarship program or for a building campaign that's going on, and that's called a restricted gift. Once that restricted gift is received by the charity, they have to use it for that restricted purpose, and it becomes a restricted charitable purpose trust. If they fail to fulfill the restrictions that I impose, there could be a breach of trust allegation brought against the charity. So charities with restricted gifts need to know what the donor restrictions are, the legal implications of those restrictions, and the need for the charity to comply. So very quickly, we'll talk about this a bit later in the presentation. There are different types of restrictions. There's time restrictions. You can have endowments or long-term gifts where the capital is held either permanently or for a set period of time, and only the income used for the general charitable purposes or a donor restricted purpose, excuse me. You can have use restrictions that the donor imposes restrictions on how the capital or the income is used for a particular purpose. And often gifts will have both time and use restrictions. You'll see some other types of gifts at the bottom of the slide. I can't speak to those given time constraints, but just to let you know, there's lots of variations of gifts out there as well.
Okay, and thanks, Jackie. So going back to the topic of gift acceptance policies, I spoke briefly before about some considerations that you want to consider when drafting them. Some key issues to address when setting out a gift acceptance policy. There are a number set out here. The top one there deals with outlining the duties of the directors regarding charitable gifts. So directors, are oftentimes forgotten when it comes to gift acceptance policies and the impact that it can have on them. So gift acceptance policy can be seen as, all right, this is a great tool in making sure that, the charity is able to accept lots of funds and really have a robust fundraising campaign. But if there are any mistakes or the charity, is alleged to have mismanaged those charitable gifts or misapplied any of those charitable gifts, then the directors can be responsible for those. So it's a good idea when thinking about gift acceptance to consider, the impact that can have on the board as well. A gift acceptance policy should also set out, the basic rules for receipting that apply to gifts and how that comes from an Income Tax Act standpoint and CRA, but also explaining the different types of gifts that Jackie just set out in that, so that there's a document that staff and volunteers can refer to in order to understand those different types of gifts, and then also gifts and kind. So gifts in kind is often sometimes a topic that's charities might need some assistance with. So basically anything that's not cash. So a gift in kind can be art, it could be shares. There are many things of that nature. So these are a number of key issues to address when setting out gift acceptance policies. And also, a charity such as a university or a hospital may have a parallel foundation. And so, the gift acceptance policy may in fact be that of the foundation, or it may need to set out, the role of the foundation in that process. Should also, as I said, set out some basic rules for staff and volunteers. So Jackie talked about the common law definition of a gift. That can sometimes be slightly modified by the Income Tax Act and CRA in terms of having split receipting rules, so allowing for some consideration coming back to the donor and wanting to make sure that you can show there's an intention to donate by not having the advantage that the donor is receiving being so excessive that it seems like they didn't mean to do that. Also, and a really important topic that comes up many times in gift acceptance and planning for policies is how you'll establish fair market value. And so that means, whether the donor is going to have their appraiser, whether the charity is going to have their appraiser, how many appraisals are needed in order to evidence, gift in kind that are being receipted by the charity, and, making sure that the charity is getting that right. And that leads into the next slide, because if a mistake is made with the receipt, it's not the donor's fault or their family or anything like that. It's the charity. And so the charity has the onus to get it right. And so, as I said before, there can be consequences. This slide sets out some of the monetary consequences that could apply if receipting is done wrong. And so having a document like a gift acceptance policy that works hand in glove again with the gift donation agreement can help make sure that these consequences can be avoided. And so Jackie mentioned on one of her slides that at the bottom there were a number of different types of gifts that we couldn't get into in more detail, but a gift acceptance policy can. And so the gift acceptance policy can set out the different requirements that are going to be needed in order for them to be a gift, how they might be processed or managed differently, what kind of acknowledgement the charity wants to provide to a donor, and then again, importantly, receipting for those and how to make sure that the receipting is doing it right. As I said before, a gift acceptance policy applied consistently, can help a charity say no. And so you can set out in that policy types of gifts that the charity is not prepared to accept. That can be for ethical concerns, depending on the charity, if it has a religious background or something, or things like that. Or it can be for practical concerns, for large gifts that the charity is not willing to administer, and things of that nature. And then a policy should also explore some of the more newer kind of hot topics with gifts, like cryptocurrency, things like that, and whether the charity wants to accept those, and if it does, the process that it's going to use to accept those. Lastly, there's just a few special issues that the gift acceptance policy may want to look at as well. Disbursement quota rules are kind of always in flux and always changing. The annual federal budget often provides some tweaks to those, and so having a policy like a gift acceptance policy needs to be evergreen, in the sense that it's going to be reviewed regularly to keep on top of those issues that might change that are set out here.
Great. It's back to me. We're going to talk about some key components in donor or gift agreements. The first and one of the most important things to have in your gift agreement is a full description of any restricted purposes that the donor wishes to place on the gift. It needs to be clear what the donor wants. The charity needs to understand what those desired restrictions are, and they can make a determination of whether they want to accept the gift with those restrictions. If the gift is to be endowed with a capital held in perpetuity, it's important that the agreement address the issue of whether there can be encroachment on the capital at any time and for what reasons. Usually those reasons are to meet disbursement quota obligations of the charity, or sometimes the charity will be in financial difficulty or have existential circumstances that come up, and they may need to access the capital. The agreement has to authorize that from the outset. Depending on the size of the gift, there may be naming rights that are provided to the donor, and you want to set out the details of those naming rights in the agreement so it's clear to all the parties. If there are naming rights, you need to work out with the donor how long those naming rights are to be in place and what circumstances could lead to the termination of naming rights. Some gift agreements, but not all, also have a feature of giving the donor ongoing ability to provide advice to the charity on how the gift is to be utilized by the charity. But you want to avoid too much control by the donor once the gift is made. Important in the gift agreement to deal with both investment and disbursement issues. How's the capital to be invested? Is it under the requirements of the Trustee Act here in Ontario, or equivalent statute in other provinces, or different investment powers as set out in the charity's investment policy? If there's no time restriction imposed by the donor, then the gift is to be expended in a timely manner by the charity. But if there is a time restriction, then we need to deal with whether all the income's to be expended in a particular year, or whether a portion has to be added back to the capital to keep it growing with inflation. I also want to deal with how you calculate income, the classic or common law calculation, which doesn't include capital gains, or the total return approach, which does. Gift agreements often deal with administrative fees, whether they can be charged, whether there's a cap on them, and how the fee is determined, and there's different ways to do it. An important provision to have in a gift agreement is the ability for the charity to vary the restricted terms imposed on the gift by the donor in the event that they become impossible or impracticable for some reason at a future date. Some agreements allow the charity to consult with the donor on a change, but the donor cannot have decision-making authority in this area. And then some other issues you'll see here, whether a change of trustee to move the gift over to another charity is possible, whether how to deal with the return of a gift, and confirming in the agreement that the donor had the opportunity to get independent legal advice. So you see on this slide a whole bunch of different types of agreements. We've talked about some of them already in this presentation. I'll bring your attention to some key donor related documents that we create. In addition to template agreements, we have template bequest clauses that charities often prepare and make available to donors who want to make testamentary gifts, gifts that come over to the charity on their death. And then it may be that the charity from time to time wants to set up their own restricted fund. They set it up internally. They set out the terms of that fund, and then they solicit donations from their donors to that internally established restricted fund. So that's another template that can be prepared and put in your arsenal. I'm going to turn it back to Ryan to start talking to you about some key takeaways from our presentation today.
Thanks, Jackie. Okay, so we hope everyone understood, the importance of having robust gift acceptance policies and gift agreements of different types of templates, of different needs that the charity might have, and a gift acceptance policy that can be cross-referenced in those agreements, and that the gift acceptance policy can also cross-reference to those agreements, and making sure that they're speaking to each other so that you have an integrated approach in developing those. So those documents working together, as I said before, can help facilitate a robust sort of plan giving program that can help attract donations to the charity and also help the charity to make sure that they're managing those appropriately, not having any misapplication of those or mismanagement, and being able to effectively track any restrictions or any other issues that come with those gifts as they come in. And so that will allow the charity in using those consistently to ensure that it's compliant. And it's compliant from a number of perspectives in dealing with its registration as a charity, but also with the common law and regulations under the Charities Accounting Act here in Ontario in terms of how it sort of holds those funds so that they're able to, do so in a compliant manner and also keep their donors happy so that they want to return with more donations to the charity.
And just to finish up, charities need to be using both sets of these documents together. They're integrated and they work together. And so they're living documents as well. They have to be consistently reviewed by the charity and its board or committees established for that purpose, and then updated accordingly, and doing that in a coordinated manner between the two documents. We covered a lot today, and very quickly, if you're looking for a deeper dive on the topics that we've talked about today, you'll see some resources that are available on our firm's website. And thank you very much for your attention today. It's a complicated topic, but a very important one.
Thank you.
Okay, thank you very much, Jackie and Ryan, for kicking things off with such an excellent seminar. Next up, we have Esther Shaneblum, a partner from our Ottawa office, and Cameron Axford, an associate from our Orangeville office. They'll be discussing IT and data management board governance issues to consider, which is a very hot button topic right now.
So thank you, CPAL, for that introduction. Thank you, Ryan and Jackie, for your wonderful presentation, and let's get into it. So, setting the stage. Charities and not-for-profits, or as we will refer to them as not-for-profit corporations or organizations, depend on their IT technology infrastructure to manage and administer their overall operations. As corporations become increasingly dependent on their IT infrastructure, the greater the risk to the corporation if there's an IT failure or interruption, and the greater portion of its budget it must allocate to remedy this failure. A lot of software, hardware that we're using in our day-to-day business is what we would describe as mission critical, which means that this infrastructure is so important to our operations, we cannot function without it, and it could lead to business interruptions, which could be catastrophic for an organization depending on their financial situations. Directors must consider how reliant the corporation is on the IT infrastructure, what possible risks may exist, and what strategies are necessary to address these risks. This presentation reviews board governance issues as they relate to IT and data management. First, though, we need to understand the risks involved and basic governance principles. So, understanding the risk. Like for-profit organizations, not-for-profit organizations are increasingly reliant on IT infrastructure for core operational functions, like managing their activities, overseeing employees, serving clients, and so on. Organizations are active in the digital online landscape, including your public-facing website, your online presence on social media or other platforms, online donation platforms, as well as cloud-based platforms for business processes like Zoom, Microsoft Teams, Outlook, any program that you're using on your devices. So why does effective IT governance matter? So it safeguards donor trust. Protecting donor trust ensures that this trust remains, that your relationships are strong, and encourages continued support. Data breaches can damage your reputation and erode public confidence. If you are involved in some sort of scandal regarding security, cybersecurity, data breaches, loss of personal information, this may make donors hesitant to continue supporting you. Enhancing your operational efficiency. Effective data management streamlines operations, reduces redundancies, facilitates informed decision-making, and just makes you more overall efficient, lightweight, more dynamic, aerodynamic. Mitigating security risks. Proactive IT management helps identify and address vulnerabilities, will reduce the risk of cyber threats, privacy and data breaches, business interruption, and financial losses. And support mission fulfillment. Clear, organized data supports transparent reporting and strategic planning, helping corporations to measure impact, set goals, and fulfill their missions. And I will now turn it over to my colleague Esther.
Thanks, Cameron. That was excellent. And I have a cold, so I apologize if I sound a bit hoarse. So Cameron gave us sort of a high-level discussion of some of the risks. We're going to do a little bit more of a deeper dive into what is some of the main risks that directors and officers should be aware of. The number one risk, which I'm sure you've figured out on your own, is the threat of cybersecurity threats. There are numbers of bad actors out there from everywhere from private mafia-style criminals to government actors who are looking to infiltrate Canadian and other Western data. So this is a real threat. In 2024, a recent IBM study showed that Canadian organizations that experienced a cybersecurity attack paid an average cost of $6 million plus to rectify the implications of the breach and the impact of the breach. For those who were the victims of a ransomware attack, ransoms have gone up a lot in the last couple of years. You know, I've done presentations before on that issue. So the average ransom now is over $1 million per attack, which has gone up almost double in the last 2 years. Most companies, more than half, say it took them more than a month to recover from an attack. Many say it took longer than 4 months. Next slide, please. The next biggest risk or related risk that Cameron alluded to is business interruption risk. The heavier your organization's reliance on your IT infrastructure, the greater the risk that if something goes wrong, you will experience a business interruption, which could be damaging to your operations, long-term or short-term. Interruptions can be caused from a wide variety of incidents, including a cyber attack, equipment failure, fire or flood that destroys your IT equipment, human error, power failures, or a supplier breakdown. Any of these can shut down your operations or severely restrict them. There was a big failure this past summer. Many of you may have noticed. It was called CrowdStrike, a very popular software that most of us had never heard of until this event. Some kind of an update was done, and the effect was to bring down the entire CrowdStrike platform, which had the effect of impacting organizations across the world, mostly in the travel industry, but also in healthcare and finance, which obviously was detrimental to them and was absolutely an external cause that they could never have prevented. And similarly, if you're relying on a crowd service provider for core business functions like e-commerce, if it goes down, you're going to go down with it. Next slide, please. And the last one that I wanted to bring to your attention relates to a slightly different risk, the risk that the actual implementation of an IT program in your organization could in itself pose a risk. As you know, and we'll be talking about this in a few minutes, directors of charities, and particularly in Ontario, you have a fiduciary duty to act in the best interest of the corporation. And let me rephrase that. All directors have a fiduciary duty to act in the best interest of their corporation. But if you're a charity, you have an enhanced duty, and you must safeguard the charitable assets. So that includes when you're spending corporate resources, charitable resources on an IT investment. Some of them can be so large and can impact the organization so broadly that it can pose a risk to the actual existence of the entity. A recent study showed that almost 20% of large IT projects go so wrong that they can actually threaten the existence of the organization. Half of large IT products go over budget and timelines, and many of them don't deliver the promised return on investment. So you could be looking at a situation where you're over budget and your actual anticipated benefits don't materialize. Next slide, please. And over to you, Cameron.
Thank you, Esther. So I would just like to quickly go over what do we mean by good governance. So good governance includes having clear lines of accountability and responsibility and ensures that the corporation acts in accordance with the law. The goal of good governance should be to ensure the effectiveness, credibility, and sustainability of the corporation. Risk oversight is increasingly seen as a key competence of the board of directors. And effective management of the corporation's IT infrastructure, including appropriate risk management strategies, are an essential aspect of corporate governance. Well, let's quickly talk about statutory duties. So under the Canada Not-for-Profit Corporations Act and the Ontario Not-for-Profit Corporations Act, the directors have a duty to, quote, manage or supervise the management of the activities and the affairs of the corporation. Fulfilling this duty includes ensuring that the purpose with which the corporation is established for are properly carried out, that the corporation is financially stable, that there's proper management of corporate assets, that there's proper management of the hiring, training, and supervision of employees, staff, volunteers, and that the overall operating integrity of the corporation is maintained. This does not involve interference with the day-to-day operations of lower tier employees or volunteers, as Esther had so wonderfully put it. You don't have to count paperclips as a director. And I will send it over to Esther for the next part.
Thanks, Cameron. So under the statutes that govern charitable and not-for-profit corporations in Canada and Ontario, every director and officer has a duty established under the Act to act honestly and in good faith with a view to the best interests of the corporation. So this statutory duty actually has its roots in the common law, ancient common law duty of fiduciary duty of directors to act honestly and in good faith in the best interest of the corporation as well, which will be discussed in a few minutes. Further, under these statutes, directors and officers also have the duty to exercise the care, diligence, and skill that a reasonably prudent person would exercise. So essentially, if there was a complaint or a challenge of actions that were taken by a director or officer, the court would examine whether they had acted honestly and in good faith and in the best interest of the corporation, and whether in exercising their oversight of the corporation, they had exercised the care, diligence, and skill of a reasonably prudent person. Next slide, please. So I don't want to go into these in too much detail. We don't have the time, but we have talked about this, and there's a lot of resources available on our website about these fundamental common law duties of directors and officers. They all really stem from the primary duty, which is the one at the very top of the chart, the duty to act in good faith with honesty and loyalty. So that's kind of the fundamental platform from which all the other directors' duties emanate. Next slide, please. And then, as I mentioned before, in addition to those primary fiduciary duties, which are imposed on all directors of not-for-profit corporations, there are additional or enhanced higher fiduciary duties for charitable directors, including the duty, as I mentioned before, to protect and conserve charitable property. So these need to be borne in mind when you're running your IT program, that you're doing it in the context of the risks and the duties that we have now mentioned. And then over to you, Cameron.
So I'm sure by this point you're wondering, what are your IT governance responsibilities? So effective management of a corporation's IT infrastructure will include the following. It involves approving, reviewing, and implementing IT governance policy and framework. And this includes setting out criteria and thresholds for IT decision-making, determining how IT investment requests are initiated, reviewed, and the approval process for these. It involves looking at roles and accountabilities of different members of your organization. And it entails, you should consider establishing an IT committee to lead IT decision-making. Now, a practical point on this can be either repurposed from an already existing committee that you may have within your organization, or it can be created whole cloth for the purpose. Let's say you already have a committee that deals with acquiring IT software. You may have this if you're a larger organization. You might want to just simply task them with the responsibility of being your IT committee. If you want to create an IT committee whole cloth, you should draw on different parts of your organization. It will require somebody from the board to oversee, but if you have an IT department, you should most definitely include somebody from that department within the committee, as they will have the practical know-how and be aware of the broader trends that are going on within the IT sector. So effective IT governance will also include establishing and improving the organization's IT objectives. You will first need to identify your corporate needs and demands, and you will need to select software and technology and ensure that they align with your business objectives. There might be some great software out there, but it might not serve the purposes that you need served. And then, as a member of a board of directors, you yourself should be aware of technology trends broadly. Now, you're not going to be an expert in these issues, but let's take AI, for example. You should be aware that we're living in a world where AI is becoming increasingly more prevalent in all sectors, and you should be aware of what that will mean for your organization in the short term. So effective IT governance will also require you to oversee IT resources and manage your expenditures. As we discussed earlier in the presentation, it is very easy for organizations to overspend. We are aware of instances where organizations have been sold a bill of goods by a vendor. They've been told that, this product is going to absolutely change everything, and it can be ruinous to an organization. Managing risk and compliance is also essential. So, being informed about cybersecurity and other IT-related risks and the corporation's exposure. You must proactively identify, manage, and mitigate IT-related risks. You need to ensure that the organization is compliant with laws and best practices. You need to put in place policies and procedures, including protocols for safeguarding personal information, protecting at-risk assets, and responding to security breaches. And I will pass it off to Esther for the next section.
Thanks, Cameron. So what are some practical steps that you can actually take as a director or an officer of a charity or a not-for-profit? Because we've been talking in sort of theoretical terms, but what do we do as an actual person who's in that role to mitigate the risks that we've described today? So, and we've also mentioned the fact that court might be looking at what you've done to determine whether you've in fact met the fiduciary and common law duties, as well as the standard of care that directors and officers must comply with. So there is something you should be aware of, which is nice. It's this business judgment rule, which is a judge-made rule that essentially says a court will not second guess a board of directors that acted prudently and on a reasonably informed basis. So even if the decision you made goes terribly wrong, if you can demonstrate to the court that you actually did act prudently, that you were reasonably informed, that you took the appropriate steps to identify and mitigate the risks we've talked about, the court will not find you liable. In other words, perfection is not the required goal. The goal is to meet the standard of care and fulfill your fiduciary duties in decision making. So how do you do that? First step is to actually conduct an audit to understand what your corporation's assets and IT risk related exposures are. That entails learning what systems you use, what you do with them, and how much you rely on them. Next slide, please. And then also sort of doing a risk assessment where you identify known and unknown risks, including what risk you're exposed to for business interruption, potential statutory or contract breaches, potential areas or touch points where personal information could be breached. You're looking for weaknesses and failure points that you can then go ahead and mitigate. You should know what kind of data you have, where is it, what jurisdiction it is, how much of it is sensitive and personal, and how do you protect it. You're basically challenging the robustness and resiliency of your system. You need to consider who should take care of this audit for you. You can employ internal staff if you have competent staff, but you might prefer to have external professional advisors that can provide the board with a really good advice that it can then demonstrate it received and that it relied upon, which would help in proving that it's exercised its due diligence and fulfilled the standard of care that we talked about. Once the audit is complete, the board should analyze it and discuss it, and as well as the recommendations that were made, so that it's not just an empty document. You're actually looking at it with a view to fulfilling the recommendations. Next slide, please.
So in the interest of time, rather than just reading through this slide, I'm just going to give an anecdote. In 2017, there's an American organization called Equifax, and they had a data breach that year, which was so catastrophic that they made vulnerable the data of 150 million Americans. That's almost half of the people in the United States. I'm sure you can imagine how costly that was for them. And the reason that happened, they did not manage their assets. They did not apply a patch to privacy software that they had. So, moral of the story of this slide is make sure that you know what you have and you know that what you have is working effectively. Next slide, please. And regular education. As we've alluded to before, you need to be up to date on what's going on in the IT sphere. As a director, there's a certain level of knowledge, but the people on your IT committee absolutely must be competent in this field. You need to be informed about best IT practices. You need to understand relevant laws, regulations, government policies, accounting requirements, and any other obligations that the organization will be required to comply with. And I think I'm giving it off to Esther to finish us up.
Thank you, Cameron. So, as we've mentioned before, it's important. Yes, okay. You're going to establish your IT committee that we mentioned earlier. It just needs to implement that governance policy, IT governance framework that we talked about, including outside experts, senior management, directors. You need to get reports from management. The best way to protect yourself as a director is to obtain reports from management confirming that you are in compliance with your legal and statutory obligations regarding cybersecurity, response to privacy breaches and data breaches, that you've got a cybersecurity plan, and that basically you get these reports from management regularly and reflect them in your minutes so that you can demonstrate you fulfilled your due diligence obligations. This is evidence that will protect you in the event of an incident. I'm speeding up because I'm being waved at. Next slide, please. Really important to get expert advice. The statute will allow you to rely on IT expert advice to show that you have done your due diligence, and also have as I said, reflect the minutes that the experts have provided the board with this advice. And finally, it's really important to get expert insurance advice to make sure you have adequate insurance in place, especially cyber insurance, to protect you from IT-related risks, such as a cyber attack or a privacy breach that could cost your organization a great deal of money and reputational damage. And we will not go with the key takeaways. I think it's self-explanatory. I hope this presentation has been helpful. Thank you.
Well, thanks very much, Esther and Cameron. Covered a lot of territory. Thank you so much for the takeaways in the PowerPoints that will be very useful for the audience later. So thank you for that. I'm now going to move over to the next topic, which is a very important one: protecting communications in anticipation of lawsuits and CRA audits. And we have Sean Carter, a partner with the Toronto office, and Heidi LeBlanc, a litigator as well, are going to give us some insights on what this is about. So Sean and Heidi, delighted to have you, and over to you.
Great. Thanks so much, Terry. Good morning, everyone. This morning, I'm Sean Carter, as Terry said, and I'm here with my litigation colleague, Heidi LeBlanc, and we'll be talking to you about protecting communications in anticipation of lawsuits and CRA audits. Just as an overview of what we're going to be dealing with, it's really about disclosure, and what we're going to talk about is privilege. In non-legalese parlance, what we're really talking about is preparing for situations that your organization's documentation, and documentation can be anything from an audio file, a video file, handwritten records, anything like that. Preparing for situations that they may be disclosed. That could happen under the CRA audits or in the context of civil litigation. And understanding that in both those situations, there's a huge breadth of information that might have to be turned over in the context of the litigation or the audit. The one exception to that is what is called privilege. And there's several different types of privilege. We'll walk you through it. And this is what we want to try to help organizations and charities understand, is how to assert that privilege, because if you don't learn how to assert it, what it is, you can lose it very quickly. So just in terms of the overview and what we're going to be talking, the general issues we're going to be talking about. First will be, what are your disclosure obligations? What's required to be produced during an ongoing litigation? What is required to be produced during a CRA audit? And what are the potential impacts of this? And then second, we're going to describe a little bit more about what type of privileges actually exist and explain those to you. And then probably the most important part will be C, which is the common pitfalls and how these can be avoided. What are the practical points that you can take away from this and help to assert and ensure that if there is communications, particularly with your lawyers, which is called solicitor-client privilege, and we'll get into, that will be protected, because you'll be surprised how easily it can be lost, and it's important to understand. And then we'll end off with some key takeaways too. So I'll just hand it over to my colleague, Heidi LeBlanc, for the next slide. Thanks.
Yeah, good morning, everyone. So before we can start to think about how best to protect our communications, we need to think about what our disclosure obligations actually are and when they will be triggered. So one of the processes that can trigger your disclosure obligations is, of course, ongoing civil litigation or the commencement of litigation. So your organization is going to have some certain disclosure obligations, which broadly are going to be that a party that's involved in litigation is going to be required to disclose all relevant documents in their power, possession, and control, unless it is subject to a type of privilege. Now, these documents have to be relevant to the pleadings, but as you can understand, that's a pretty wide breadth. The court has the ability to order production if things are not willingly tossed over. And if there's any sort of dispute about whether or not privilege can actually be claimed, the court can inspect the document and determine whether or not privilege has been properly claimed and whether the document can actually be produced. Now, of course, if parties don't live up to their disclosure obligations, there's going to be some pretty severe consequences. So the court is going to be able to in some cases, strike a party's defense if they don't comply with their disclosure obligations, or even dismiss a claim altogether. Also very important to preserve any documents that may be involved or maybe need to be disclosed in a sort of anticipated litigation. And there are some consequences there as well if a document is damaged or lost, and the court can actually infer an adverse interest against the offending party.
Great. So other than civil litigation, another very relevant, obviously, to the organizations that are watching right now is what would happen if a CRA audit came? And what are the types of powers that CRA would have to produce information? And what could you, privilege could you assert to avoid having to produce certain types of communications? So very generally, CRA officials are entitled to request and examine all relevant materials and or records of a registered charity or not-for-profit organization as a taxpayer under the Income Tax Act, and any other document of that taxpayer that may relate to the records or purposes or the administration of the Income Tax Act. So as I said before, this could be anything from emails, it could be personal emails, potentially, if they're about the operations of the organization, financial information, corporate records, correspondence, and as I said, even audio, video, books, all these great swath of things that could be encompassed and produced under a CRA audit. In both the civil litigation and CRA audit situation, both, just so everybody would understand, we're talking about this privilege that could be asserted. The process that would happen if you would not want to produce certain documents, and say the other party or CRA wanted you to produce it, you would have to go before a judge. So one thing that Heidi and I will be talking about today is essentially you want to prepare for that moment, lay that narrative, because it will likely be reviewed, potentially, not likely, but it could be reviewed at a later time. So be careful, as we'll explain going through the different types, about how you record your different type of information and how you store it. Similar, as we said, similar to civil litigation, CRA auditors cannot compel the production of information over documents which are subject to privilege. And the different types of privilege we'll talk about in just a minute. On to you, Heidi.
Yeah, and so before we get over to the different types of privilege, just thinking practically about what sort of the implications of these disclosure obligations actually are. Firstly, and one of the most important implications for organizations is going to be that these disclosure obligations can really arise at any time, and outside of the organization's control. Essentially, obviously, a CRA audit can arise at any time, and an organization can be brought into litigation, whether it's brought in as a third party, as a defendant, or even it commences a claim. And then secondly, it's also important to remember that just because a document may be confidential or secretive or potentially harmful, or contains sensitive information, doesn't necessarily mean that it's going to be privileged. So it's really important to understand what privilege actually means, and what protections are available to you. So over to Sean to discuss the first type of privilege.
Great. So the first type of privilege that we're going to get into is what I often refer to as the strongest and I think the most all-encompassing, which is the solicitor-client privilege. That is communications, and it protects communications between a lawyer and a client for the purposes of obtaining legal advice and is intended to keep confidential between those parties. This privilege, as we'll discuss when we talk about other ones, you'll notice is one that will last the longest. It lasts for the life of the organization. It's just not for the life of an audit. It's not there for just the life of of litigation. Solicitor-client privilege information, you getting legal advice, is protected for the entirety of either the individual's life or the organization's life. And we've set down here, and we'll set down in each slide some of the main cases that talk about this, talk about these leading cases on the subject of privilege. But we're not going to go into them, but just to let you, if you would like to look up, you can look those up and get a little bit more information on them. Very generally, back about 20, 30 years ago, there were about 15 to 20 types of litigation. The Supreme Court narrowed it down significantly. We're going to talk about what little later about a basket privilege, but it's being whittled down to about 5 different types of privilege. And the first one, as I've talked about, is solicitor-client privilege, and is the broadest and protects you and your lawyer talking and getting legal information and ensuring that that's protected. So I'll turn it now over to Heidi to talk about the next one.
Yeah, and so the next type of privilege is litigation privilege. So it protects against the disclosure of documents which are prepared for the purpose of litigation. And so the elements are listed here on the slide, but the main sort of pain points here in demonstrating a proper claim for litigation privilege will be whether or not litigation is actually in reasonable prospect, whether or not there's actually a threat of litigation, or whether or not the document has actually been created for the dominant purpose of use in litigation. And there's a very specific dominant purpose test that unfortunately we don't have time to go into today, but those are sort of the main issues here. And the other last thing that's very important to remember about litigation privilege is that it really can only be asserted during the litigation process itself or in anticipation of litigation, and doesn't survive once the litigation has actually concluded, whether that be by a court judgment or a settlement. Over to you, Sean.
Thanks, Heidi. So the next one is settlement privilege. And this is an example of one I would say that was very much on the other end of the spectrum from solicitor-client privilege. Settlement privilege is very limited in terms of the time that it's applied, but it still can be important. It doesn't exist for the life of the organization or the life of the person, but it simply protects the confidentiality of communications and information that is exchanged for the purposes of settling a dispute, in discussions with the context also of mediation. So this one will protect even sometimes before litigation has actually commenced, if litigation is contemplated. So that's important to remember. But another thing that's important to remember, and this goes back to the point that I made about making sure that these communications are done in such a way that they, remembering that they may be reviewed out of court for some time. This is the perfect example. They will almost certainly be reviewed out of court at some time, especially in the civil litigation process, because settlement privilege is then no longer applies when you're expressing or making cost arguments. So that's important to keep in mind. And I'll turn it over to Heidi for the next slide.
Yeah, so the next type of quote unquote privilege, this one's a bit of a strange one, but it's called common interest. And it allows for documents or communications to be that are covered by another type of privilege to actually be shared between parties that have a common interest and where there's a mutual intention to keep documents or communications confidential. So very important here to understand that there needs to be a pre-existing type of privilege that applies. And also something that's very important is that common interest privilege is not going to apply typically where participants just merely have sort of common problems. And it's really best for there to be some sort of common interest arrangement regarding the scope of the material that's going to be covered, and to put that in writing in order to make sure that everyone understands what's going to be shared and what they're trying to assert privilege over. Otherwise, privilege protections may not apply and privilege may be lost. Next type of privilege, over to you, Sean.
Great. The next one is called Wigmore privilege. I'll just quickly refer to this. This is a complicated privilege that you would want to get some legal advice on. Essentially, it's a basket privilege where we used to have privileges like doctor-patient, priest-penitent privilege. It's now all assessed under this particular test that's set out here on the slide, which you can review. This also, and most importantly, only applies and is assessed for each particular communication. So it's not a blanket communication like solicitor-client privilege. Each particular email, each particular communication, whatever that might be, is going to be assessed by this particular test. I'll turn it over to you, Heidi.
Yeah, thank you, Sean. Okay, so now that we've reviewed the different types of privilege and our disclosure obligations, now we can talk about what might be some common pitfalls and perhaps some strategies that your organization may be able to employ in order to avoid these pitfalls. So firstly, just remembering that not all communications with your legal counsel are actually going to be privileged. So not all communications with your legal counsel are automatically privileged as of right. As Sean was explaining earlier, those communications need to be for the purpose of seeking, formulating, or giving legal advice in order for the privilege to apply. So that is a little bit more specific than just any communication with your counsel. So something that some tactics people try to employ sometimes are to simply copy their legal counsel on communications in hopes that this means that they'll be able to claim privilege over the communication. But simply copying your lawyer on an email or a letter doesn't necessarily mean that the communication is going to be properly privileged. Similarly, looping your lawyer in on a portion of a chain of an email is also not going to result in privilege, not necessarily going to result in privilege protections.
All right, the next one is to be aware of inadvertent waiver of solicitor-client privilege. So just quickly just to highlight some things for you. First of all, copying parties on an email, maybe they're former board members, maybe they're family members. As soon as you do that with a communication that's privileged, say solicitor-client, legal advice, even if it's somebody who was involved in your organization before, if they're not currently, that's an automatic waiver of privilege. And just for time, I'm now going to hand it over to you, Heidi, to go on to the next one.
Yeah, sure. Thanks, Sean. So the next one deals with when people put labels on different communications or documents, such as confidential, without prejudice, or privileged. And This doesn't, including these labels on documents or communications, very important to remember, this doesn't mean that they are automatically covered by privilege. And the content of the communication itself is going to need to be assessed as to whether or not privilege applies. Of course, you can continue to use these labels for internal or other purposes, but just understanding that you can't rely on them, just slapping a label on there isn't going to mean that it's necessarily covered by privilege.
Right. And the next one is to keep control over the information, your privileged information within your organization. So keeping it, this is kind of a best practices, keeping it within a particular possible area of your server or particular small group of people. The rest of the information's on the slide, which I won't go through for time, but it's important to think proactively about it and to ensure that none of these trip ups that we're discussing are hit. Turn it over to you, Heidi.
Thanks, Sean. So similarly, sharing sensitive or confidential information outside of your organization should also be approached with extreme caution. Sort of similar risks as Sean was discussing with respect to these inadvertent waivers of privilege. And also, the more that you share outside of your organization runs the risk of inquiries being made of whomever it is that you shared it with as to what was shared with them and why. And the organization then can sort of lose control over what is being said. And things can obviously, you can run the risk of things being disrupted by way of sort of the telephone game and the rumor mill and that sort of thing. So it should certainly be limited as much as possible, sharing information outside of your organization. And as Sean mentioned, this includes former members or directors and also any friends and family, just to avoid that sort of Pandora's box of inquiries to these other people outside of your organization.
Right. The next one is just a simple proactive advice of try to avoid using especially personal email accounts when dealing with the organization. If there's an audit, if there is a disclosure request, you may have to filter through a lot of personal, which is organization, which are my personal emails. It's a lot easier if you either establish or you have your organization's own email account. And that goes same for devices too, if possible. Makes it a lot faster and a lot easier to protect. Hand it over to you, Heidi.
Thanks, Sean. So lastly, and this one may be the most complicated, is maintaining privilege in communications with third-party advisors or experts. So of course, there's no inherent legal privilege with respect to these types of relationships, like Sean was saying before. Of course, Wigmore or case-by-case privilege might apply, also solicitor-client privilege or perhaps litigation privilege, but this has to be approached very cautiously. And today we're going to look at the example specifically of solicitor-client privilege and how that relates to communications with third-party advisors. And essentially, solicitor-client privilege can extend to the continuum of communications in which the lawyer is providing its legal advice, where a third party is actually engaged by the lawyer for the purposes of providing that advice. There's a recent Tax Court of Canada case that's listed here, which discusses this in more depth, but essentially just ensuring that the nature and scope of the relationship between the lawyer, the third party, and the client is very carefully defined and limited to ensure that privilege can actually be claimed. And also the retainer relationship. Best practice is essentially that the lawyer should retain the third party directly, regardless of who's actually paying the third party. And then the content of the communication should be limited to the defined scope of the relationship.
Right. And just the final two slides for you is that privilege is a powerful tool, but you've got to use it, you've got to understand it to protect it, or else you're going to lose it. Very simple. And the key takeaways: understanding the reality of disclosure obligations. A lot of people, if they slap confidential and private on their correspondence, it'll be privileged. It's not true. You've got to fall under one of these privileges that we've discussed. There's no blanket rule. The labeling, as I just said, the document as privileged or confidential does not automatically mean that it's privileged. And again, this happens so many times, and I've gone through audits with many of the lawyers here at the firm. One of the ways that clients have most often inadvertently given away their privilege is by sending it to that former director. You're having a conversation, that director cares, or it's a family member that knows a lot about the organization. or closely held. So it's very important to remember. Thank you all so much for listening and paying attention, and thank you so much.
Thanks, everyone.
Okay, thank you so much, Sean and Heidi, for guiding us through a really, really challenging topic and breaking it down so effectively. Next up, we have Barry Kwasniewski from our Ottawa office here, and Martin Wismath, an associate from the Orangeville office. They're going to be discussing a topic that's probably relevant to everybody listening: essential employment law updates for our charities and not-for-profits. So, Barry and Martin, over to you.
Thank you, CPAL, and welcome everyone to today's presentation on employment law. Today, we're going to have a discussion about 3 interesting wrongful dismissal cases that have come out in the past year. And we're going to discuss in particular termination clauses and how they impact the charities and not-for-profits in Ontario and in other provinces as well. And we're also going to discuss amendments to the Employment Standards Act in Ontario under the Working for Workers 4 Act and the Working for Workers 5 Act, some of which have come into force and some are awaiting proclamation. So let's get started. Martin, could you discuss the British Columbia case on in Lefebvre versus Gisborne Holdings and tell us what happened in that case?
Sure. Thanks, Barry. So this case, Lefebvre and Gisborne Holdings, was a British Columbia Supreme Court case in which the employer, as the defendant, was held liable to the employee, the plaintiff, for wrongful dismissal on a fixed-term contract. And it was an 18-month fixed-term contract to cover parental leave. And just 6 weeks into that contract, the employer, Gisborne, terminated the employee's employment. And they did not inform her that it was a termination for cause at the time. And they paid her 2 weeks of pay in lieu of reasonable notice. And as it came out later, the reasoning was that there was an email that she had sent about a client communication that then she took issue with her HR manager. And so that came out in the trial when the employee sued for wrongful dismissal. And the employer tried to argue that there was just cause because of that email. But in the decision, the court found that the email, although it was sternly worded, firmly worded, it did not rise to the level of insubordination, and it was not rude or unprofessional, and it did not undermine the manager's authority with other employees. So the court decided that termination was an extreme act, and the employer should have followed their progressive discipline policy rather than just terminate. And the damages amounted to the rest of the fixed term contract because that contract lacked an early termination clause. And the employer tried to argue that because it allowed for a $5,000 completion bonus that provided early termination, the court disagreed, found the employer liable for the remaining of the 18 months. And even though the employee had tried to argue that there were punitive damages, the court decided not to award that because there was no marked departure from decent behavior by the employer and no independent actionable wrong. So it did not meet the severe misconduct threshold. So Barry, given this case, and it's a British Columbia case, what can other employers elsewhere in Canada, charities and not-for-profits, learn from that decision?
Thanks, Martin. Well, I think this case highlights that when an employer relies on just cause as a defense to a wrongful dismissal claim, it is a difficult evidentiary burden to meet. So before terminating someone for cause, you have to be sure that you have the evidence to support it that will stand up in court, because for cause terminations most frequently result in wrongful dismissal claims. Fixed term contracts, they are very much a risk in wrongful dismissal because what happens is the court will likely require the employer to pay out the unexpired portion of the term of the fixed term contract. So charities and not-for-profits need to think, what's it going to cost the organization if we allege just cause and lose at court? Are we going to have to pay out the whole unexpired portion of the term? And how much is it going to cost us, not only to pay out the employee, but pay out legal fees as well? So important considerations there. Now, the next case I want to move on to is a recent case in 2024, Dufault versus the Corporation of the Township of Ignace. This is an Ontario Superior Court case. Again, a fixed term contract where an employer terminated the contract early, quite early, and there was 101 weeks remaining in the contract. The employer thought they could get away with paying 2 weeks termination pay, but going to court, they go and argue before the judge, and they lose. They're ordered to pay 101 weeks, over $157,000. Now, why is that? Well, the court found that the termination clauses in the particular contract, can you move the slide, please, were not enforceable because of 3 reasons, which are on the slide. I want to focus on the third reason, which is a new wrinkle in employment cases in Ontario, because this termination clause allowed the employer to terminate at any time and at its sole discretion. Those 2 short phrases included in the contract made a difference in how the court interpreted the contract and rendering it unenforceable with respect to the termination clause. So this case highlights what happens when a court strikes out a termination clause and allows the employee to be awarded what are common law damages, in this case, the entire portion of the term of the contract. This is the type of case that sometimes keeps employment lawyers up at night because there seem to be always new wrinkles in the case law, which have made it in recent years more difficult to exercise termination rights successfully on the part of employers. Now, there's another case that came out in just last month, Martin, Birch versus Data Stealth Health, Inc. And this came to a different conclusion, so maybe you can discuss what happened in that case for us.
Yeah, this case, Birch and Data Stealth Incorporated, just came out in October, and it's good news for employers compared to the last few cases because the court ruled in favor of the employer as the defendant and struck out the employee's claim without leave to amend. In this case, the employee was hired in July 2023, terminated less than a year later in June 2024. The employer paid 4 weeks termination pay, which exceeds the ESA minimum of 1 week for less than a year of employment. And the employment contract limited the termination rights to the minimum ESA entitlements, and it waived common law notice. The employee sued for wrongful dismissal and tried to argue that the termination provisions were not enforceable because the contract allowed for termination without notice, whether or not there was willful misconduct. And that's language from one of the regulations under the ESA for termination and severance. And the employee had sued for 12 months of pay in lieu of reasonable notice, which amounted to $300,000. The reasoning was that the court held the termination provisions were enforceable because they were clear and unambiguous and compliant with the ESA and the regulation under the ESA for termination and severance. The court recognized that termination clauses must always comply with the ESA, so it agreed in that regard with the last 2 cases we discussed. However, the court found that looking at the termination clause, there was no reasonable alternative interpretation that would lead to an illegal outcome because the employer always, regardless, provided the employee with his minimum entitlements. And because this was a Rule 21 motion to decide the contractual interpretation, the court held that there was no trial necessary because there were no facts in dispute. And this case, again, highlights the importance for employers, charities, and not-for-profits to always draft clear and legally compliant employment agreements with enforceable termination clauses. And it's a notable contrast to recent case law in that it sided with the employer on the enforceability of the contract. So for the next few slides, Barry, we're going to compare the last two cases, and I'll pose a few questions to you. So comparing Defoe and Birch, how are the termination provisions different in each of these cases?
Well, in the Defoe case, I want to highlight a couple of things. In the for cause termination clause in that contract, one of the instances where the employer could terminate for cause was the failure to perform services. This was found to be contrary to the ESA regulation, which limits termination for cause in circumstances where the employee is guilty of willful misconduct, willful neglect of duty, or willful disobedience. So in the Defoe case, the employer fell afoul of that ESA standard. Now, Birch, contrarily, it specifically excluded any common law entitlements beyond ESA standards, which the Defoe contract did not have, and it also clearly stated that in certain circumstances, like the one I just mentioned from the regulation, there is no entitlement to ESA payments or anything else on the basis of common law. So very different termination clauses, and of course, a better result for the employer in Birch.
Barry, then why did the termination provisions in Defoe violate the ESA, but they did not violate the ESA in Birch?
Well, there's two sections in the ESA that the court found were violated by the employer using the language at any time and at employer's sole discretion. So they refer to job protected leave, where employers are required to reinstate an employee after taking a job protected leave of absence, such as a parental or pregnancy leave. And Section 74 prevents termination as a retaliation for exercising ESA rights. For example, if an employee made a complaint to the Ministry of Labor that the employer violated some section of the ESA, an employee cannot be terminated. So what happened in that case is that the judge held that the broad definition of at any time and employer's sole discretion breached the ESA. On the other hand, as you mentioned earlier, Martin, the court found no reasonable interpretation that could lead to an illegal outcome or violate ESA minimums in Birch. So that led to the court correctly finding, in my opinion, that the termination clause was legally enforceable and ESA standards were met.
So then, given the way that courts have gone in Ontario over the last couple of years, we've seen both sides. What should employers expect with future case law in Ontario and the enforceability of termination provisions in employment contracts?
Well, there was a case in 2020 from the Ontario Court of Appeal, Waxdale versus Swagon, and it's important to note that courts now very closely examine termination clauses for ESA compliance more closely than they ever did before, in my opinion. But there remains some uncertainty as to what's going to happen next as to the enforceability of termination clauses, particularly in the province of Ontario. Every time a wrongful dismissal case ends up in court and there's a contract being interpreted, courts may come up with different interpretations of that clause because there are so many types of termination clauses in contracts. But at least for now, subject to any appeal, the Birch case does hold some hope that employer-friendly clauses will be enforced by our courts in Ontario.
Last question for this part, Barry. So, looking at these two cases and how differently they've gone for employers and employees, how can charities and not-for-profits best draft their contracts so that although they can't guarantee how a judge will decide, how can they best prepare for a decision in their favor, like the one in Birch, and not against them, like the one in Dufault?
Well, because they are subject to such close scrutiny by courts, you need to be careful how you draft your employment contracts these days. You need to pay more attention than you ever have before. And don't assume that the contracts you've been using for many years are legally secure, because in light of the decision in Waxdale that I just mentioned, clauses that have been used for many, many years are likely not going to withstand judicial scrutiny now. Now, some key lessons learned from these decisions: be careful with fixed term contracts because they can lead to substantial liability, like the case in Dufault. Avoid broad definitions of cause. Refer to the ESA standard in the regulation, which I mentioned, and avoid use of the words anytime or at sole discretion in contracts because, again, from the Dufault decision, that these simple phrases are likely going to render your termination clauses legally unenforceable. Martin, let's move on to the Employment Standards Act changes with the Working for Workers Act 4 and the Working for Workers 5 Act. Perhaps you can explain for our audience what this means for them.
Sure. I'll go through this quickly since we only have a minute
Okay.
to go here. So there's been a series of acts by this Ontario government called Working for Workers Act. And these are amendments to a number of statutes, including the Employment Standards Act 2000. There were two this year. The first one was the fourth in this series, the Working for Workers 4 Act, Ontario Bill 149, received royal assent on March 21st. And notably, it's amending the ESA to require employers to put information into publicly advertised job postings. And these have not yet been proclaimed into force. So they're not yet a legal requirement, but they are in the ESA. And it would be good for employers to get in the habit of doing this when they're posting publicly advertised jobs. Three things here. Publicly advertised job postings will require employers, and I know this is unpopular among many employers, but they will have to post the expected compensation or the salary range for that position. They will also, they're also no longer allowed to require Canadian experience for publicly advertised jobs. And interestingly, now that we're in the era of AI, and because AI has been known to have a selection bias at times, if an employer is using AI to screen applicants for a publicly advertised job, that needs to be disclosed in the ad. The second of these two acts is the Working for Workers 5 Act, amended a number of statutes, including the ESA as well, added a couple requirements for publicly advertised jobs. Number one, whether it's for an existing vacancy or not. And also there are some requirements for prescribed information. We aren't sure what that is yet. And again, these are not yet proclaimed into force, and we're not sure when that will be. A couple other amendments that are in force. There was an amendment to Section 50. So employers are no longer allowed to require a certificate from a qualified health practitioner for employees to prove that they have the right or the entitlement to take sick leave. And lastly, the fines were increased for individuals up from 50,000 to 100,000. That's the same for a first-time offense for a corporation. Although corporations can be fined for a second offense up to 250,000. and thereafter up to $500,000. So some key takeaways, just quickly. Maybe we should skip this because we're out of time. Yeah, viewers can see that.
Okay, thank you, Martin and Barry. Good topics, good information, and again, the PowerPoints are rich with content, so you can use it as a reference tool going forward. We're now going to move over to our first fireside chat, and I'm delighted to be able to introduce Bruce MacDonald. Bruce is the president of Imagine Canada. And has been in the charitable sector for many, many years. Before headed up Big Sisters, Big Brothers, Big Sisters for Canada before coming over to Imagine Canada about 10 years ago. We've had Bruce before speak to us about what's happening in the sector. And our topic is going to be challenges and opportunities for the charitable and NFP sector. What to get ready for. Bruce, welcome to the Fireside Chat.
Thanks, Terry. The fire looks great. I hope you'll be keeping it stoked up as we go.
Well, I just want to mention, Bruce, over on the far right-hand side of the screen, there's an old time, like a stereo unit from the 1970s. It's great. I feel right at home. So
Perfect.
very good. So Bruce, we've got about 30 minutes or so. And so I wanted to ask you first, as we head to the sprint towards the end of 2024, what are you seeing as some of the key issues and trends affecting charities and not-for-profits?
Yeah, it's a great question. And first of all, thanks for the opportunity to be here. It's always a pleasure. And I know that there's so many organizations that are listening in today or will do so with the recording. So really thrilled to be here. In terms of some of the things we're keeping an eye on, I mean, first and foremost, just looking at this issue of supply and demand. I mean, one of the things that we saw at the start of the COVID-19 pandemic was a surge in demand for services from organizations, families who never thought they'd be standing in line for food, where both parents lost a job at times, or significant increases in intimate partner or domestic abuse cases during lockdown periods, mental health distress. So for a significant period of time, we saw this incredible increase in demand for services. And so we've been kind of looking to say, well, what's happened as the pandemic has eased and as society is returning to practices that were more familiar pre-2020. And we are still seeing that there's certain sectors that are being affected by supply and demand issues. And so, for example, most sectors, within the charitable nonprofit sector, about 21% of organizations continue to report that they're seeing an increase in demand. But there are some subsectors, some areas of the charitable or not-for-profit sector who are still over-indexing. Groups like social services at 47%, health at 41%, and the environment at 38.5%. And as well, there are some subsectors who continue to report decreases in demand. Whereas about 9.5% of organizations were saying they saw a decrease in demand. Religious groups at 16%, and arts and culture groups at 14% were seeing that they were reporting decreases in demand. And we're wondering if that's because some commonalities in those groups are place-based gatherings, where maybe some folks have still been a bit reticent to come back. Many places of worship started to offer online services, and people are continuing to do those, and a bit older crowds that are going to some of those. So sort of some interesting observations there. I think as well, keeping an eye on what's happening with donation trends. In 2022, the latest federal government data that came out this year showed that only 17.1% of Canadians are claiming the charitable tax credit on their income tax. It's the lowest number ever recorded. Donations continue to rise, though, in aggregate dollars. But what we are seeing are two other interesting and patterns that we have to ask questions about. One is out of the $12 billion that individual Canadians give, half of that comes from people over 60, and of that, half of that comes from people over 70. So this concentration of giving in older, more affluent donors. And the other thing we're noticing is that bigger charities are eating more of the donation pie. So while it's been pretty consistent for many years, At the start of the pandemic, bigger organizations had more technology in place, more systems in place. They were ready to go, and they actually are starting to capture more of the donations. So it's there, some of these classic indicators are inviting us to ask questions around what's happening. And I would say the third major trend I'll just touch on briefly is around staff burnout and turnover. And we saw many leaders at a certain vintage who stayed around during those pandemic years, are exhausted, are accelerating their retirements. And so there's a lot of questions around, is the next layer there? Are we ready to advance staff into senior roles as executive directors or CEOs? But certainly in tough hiring markets, it's a challenge for our organization to compete, to attract and retain talent. And that's one of the most common things we're hearing from organizations.
Well, thanks, Bruce. You've given us a ton of information about the sector. Some of the folks on the webinar might not know about the role of Imagine Canada. Just give us 2 sentences to
Sure.
explain what does Imagine Canada do, and what do you do with regards to the sector?
Yeah, absolutely. Well, we are a national registered charity. And essentially, what we seek to do is improve the operating environment in which social good takes place. We define we define social good as registered charities, nonprofits, because they're different, social entrepreneurs, but as well, we seek to engage and influence with government, media, and the corporate community. And we primarily do that through research, public policy at a federal level. We accredit charities for good governance, transparency, and accountability. And we work to bring more voices together to invite Canadians to think deeply about social good.
Okay. Thanks, Bruce, for that context. So it's likely that 2025 might be a federal election year, possibly. As Imagine Canada is preparing for such a possibility, what are some of the key considerations, Bruce, that you're thinking about in your team, and pieces of work that you and Imagine Canada are undertaking to prepare?
Yeah, it's a great question, Terry, because right now, according to most polls, we may be looking at a change in government if those polls hold. And it's interesting because as we think about what might transpire with a change in government, we are hearing in conversations with conservative members of parliament uh, that there may be a different way of doing business. And I know that you've got a lot of organizations online here today. And I would say that my central message as we are entering this federal election is we're asking ourselves the question, how can we mobilize and activate organizations on the ground? Because certainly the messaging we're hearing from conservative leadership is that honestly, they don't want to hear from groups like Imagine Canada. They want to hear from folks in their communities at Tim Hortons when they're knocking on doors on the front porch. And when issues related to charities and nonprofits are raised there and brought back to caucus, that will be a key listening ingredient in how they craft their thoughts around our sector. And so it's interesting because I would say that we're also preparing for the possibility of another minority government. So as we just look at the electoral map, despite a 20% poll in the lead, there's some indications that if Liberal support decreases in Quebec, that might go to the Bloc rather than the Conservatives. If the Liberal 905 in the Greater Toronto Area vote doesn't collapse, we could end up with three significant opposition parties. So we're also paying attention to what all the other parties are interested in talking about. And in terms of maybe sort of three specific things we're working on, we're heading into a sprint right now to work on the development and creation of what we're calling a nonprofit platform, a collection of ideas endorsed by charities and nonprofits that we will present in early 2025 to all of the parties for consideration. That each have a nuance according to party ideology, but we think it would be better for the federal parties as they're crafting their platforms and their first 100-day plans to take ideas that are endorsed by the sector rather than making ones up themselves. And there's lots of ideas for good public policy coming from the sector. So we're going to bring those together in a comprehensive way and invite parties to adopt the whole thing or elements out of it. The second thing that we're seeking to do a bit differently than we've done in the past is we're looking for influencers within the sector. We have many former politicians, provincially and federally, who are sitting on boards of organizations. We've got corporate leaders who have access to the halls of power, who are sitting in the boards of organizations. And we're going to be reaching out as we identify them to organizations and saying, it's great that they're supporting your cause. Do you think they might also at times support the sector writ large? Obviously be judicious with this. And the third thing is preparing the sector to engage. And that is doing some education webinars in both English and French with organizations so that they understand that the rules have changed and how can they get in the game come election time. So getting ready for what could be a very important year for us.
Bruce, in that regard, and particularly working with the federal government, I know that Imagine Canada and also with the advisory committee to the charitable sector that you and I were both on, that a priority has been the creation of a home in government for the charity and not-for-profit sector.
Mhm.
Can you speak to that? Is that a realistic objective? And if so, what do you see happening in that regard?
Yeah. Absolutely. And yes, we do think it's realistic. In fact, Terry, we are sort of rebranding it away from a home in government to more a unit or a secretariat. Our learning in talking with folks across all parties was that they were concerned that home conjured up hundreds and hundreds of civil servants, whereas we're really looking for a small unit that can help connect across the sector. And so what we're doing is having conversations around how that might work, because there is a business case to be made that having a unit inside the federal government to act as a convening and coordinating body can actually help the federal government be more effective and more efficient. So this isn't about spending more, it's about spending smarter with the investments that the federal government makes and creating efficiencies across government. And we're getting some traction on that. So we'll be continuing to advance this conversation.
And do you think that that's a conversation that all parties, including the Conservative Party, might be interested in?
Our early indications are yes.
Okay, okay. Because there certainly is a disconnect
Yes.
between what happens with finance coming up with legislation, CRA trying to implement it as a regulator, and then other different portions of the government which are not always in the loop of what's happening. Sometimes it can get out of sync. So that's a great objective, Bruce, if that's in fact going to be coming up. So thanks for that. So here's a tough question for you, Bruce. We don't bring the president and CEO of Imagine Canada without some tough questions. So over the past couple of years, we've seen more instances where charities are being added to broader actions that have political interest. For example, we are seeing the threat of revocation of charitable status becoming a starting point in proposed actions. What do you think about the politicization of charities? Any thoughts?
Well, yeah, absolutely. First of all, this is a fireside chat. We're supposed to be having cocoa and marshmallows, not hardball questions. But no, it's a great question, Terry. I mean, we're really actually quite concerned about this. You know, we are starting to see a growing sense that as elected officials are thinking about advancing their particular political and one sometimes might use partisan interests, that they're now sweeping charities into that. And we think that's a problem for a variety of reasons. One is some of these are being done without consultation. And so they're just kind of dropping. And now our job is to react and try at times push things back. We on principle disagree with any government, regardless of political stripe, weaponizing, if you will, either the Income Tax Act or CRA to go after a particular part of the sector that it doesn't happen to agree with. We are a nonpartisan sector. We don't engage. We're not allowed to engage in those kinds of conversations. And so we think it would be better that if government or particular MPs have interests that stray into services provided by charities, that we have a conversation about it. Because the other part is we should never start with revocation. We should start with a conversation about education, about are there issues that are happening? And in some cases, we've observed some of the elected officials aren't as aware that the government already has authority to do what they're creating new rules around. And so it may be simply a matter of ensuring that those folks are informed about the aspects and the parameters with which CRA works. But we don't really think it's healthy for the sector or Canada if our sector is brought into partisan conversations.
And that's a very good point, Bruce. And over the years, over the decades, working with charities, they often come with a sense of fear. And we as lawyers, we try to explain that, as you just say, the charitable status should be a neutral situation, but because of sometimes interference by the government, sometimes decades ago it used to be Jewish charities, and then it was Muslim charities, and then it was environmental charities, and now it's some pro-life groups. It depends of the particular flavor of the day, which particular issue will be utilized by governments. And it's problematic. And what it does is it detracts from the stability of the charitable sector to get on to doing purpose within community. And instead, they become concerned and defensive, and understandably so. So
Yeah.
thank you for that, Bruce.
And Terry, just one other quick point on this. We imagine Canada's been doing a series of regional consultations across the country, bringing organizations together to just talk about challenges and opportunities. And the issue of collective advocacy or being advocates for the work of their causes has come up. And I haven't seen this as much in a while. Of what I would characterize fear of reprisal is creating a hesitancy. And it's not just at the federal level, it's at a provincial level where if they speak against a government policy and they're receiving significant funds from the province, that could be a problem for them. So I think part of this work in education and talking with organizations about how to, in a sense, get in the game, it's important to get in the game, but it's also important to make sure that organizations are comfortable and play a role that works for both the staff and the board.
Bruce, you remember back in 2018, good changes to the Income Tax Act that permits charities to be involved in public policy dialogue and activities, which is good because charities do have something to say about issues that are relevant to their charitable purpose.
Absolutely.
We want to continue to encourage that, not discourage having a discourse with the charitable sector.
For sure, because you look at so many of the positive changes in our society have been a result of work, not just the work that charities and nonprofits do, but the voices they bring in terms of influencing policy change. And we want to make sure that continues.
Great. Thank you for that, Bruce. And now no more hardballs. You're going to get your cup of cocoa and put your feet up and just relax for the last couple of questions. Bruce, in looking ahead to 2025, what are some of the factors that you're keeping an eye on that you think will affect charities?
Yeah, well, again, there's lots of them. I think first of all, it's important to note it's not just at a federal level that we're likely to be entering an election period. In 2025, Nova Scotia, Newfoundland, Nunavut, Yukon all have provincial or territorial elections, and Ontario's being rumored to going to the polls early. So there's going to be lots of opportunities for organizations to influence agendas, influence platforms, and ensure that their causes are top of mind. We're also obviously looking at the state of the economy. There is an absolute correlation between the health and well-being of our sector and people having jobs and companies making profit and those kinds of things. And with the election south of the border and the campaign promise of massive tariffs, uh, we have to pay attention to what might happen to the Canadian economy if it is now more difficult for our goods to enter the market south of the border, which is, of course, our largest trading partner. And so there is a knock on or a ripple effect to the well being of charities if our economy slows down as a result of potential, tariffs that would be imposed by the incoming U.S. Federal government. In addition, global instability might be affected by the election that's happened south of the border. Um, the business community responds well to stability. If there are massive changes in U.S. foreign policy and a particular, a more isolationist mindset from the government. It might mean more instability abroad. That again affects the global economy, and there's a knock-on effect here in Canada. We're also like really paying attention to rising expectations for charities around cybersecurity and data privacy, and as well their inquiry, their questioning around uses of artificial intelligence and AI. Certainly, as more and more people are coming to us with service, as I mentioned, or for service, as I mentioned at the outset, people are entrusting their parents to a day program and providing their personal health information. They're providing their own information as donors. And there are significant expectations that that is being well protected. And if we have a disconnect as it relates to allowing organizations to spend money on infrastructure, we don't want to see a situation where there's where there's data breaches with private information held by charities and nonprofits. And so, there are lots of things happening. And I'd say the other one that we're really, leaning into a bit, and others are already in this space, but I think it's really important. Going back to those conversations, those data points around the state of donations and this concentration in older, more affluent donors, asking questions on what's happening with the incoming generations as wealth will transfer, and even and for young generations about their connection to social good, and even beyond that, where's the societal value of caring about your neighbor and your community being discussed? As we've seen in Canada, there are many aspects of where that has been traditionally learned for decades, which are softening or weakening. Mainstream Christian church attendance in Canada has continued to decline. We are a more urbanized nation, and we often see that provinces that are more rural top the list of generosity. Newfoundland, Saskatchewan, Manitoba, they're always up there in terms of giving. They're more rural provinces. Even groups like service clubs, which have come together for years to support their communities, are in membership decline. And so part of our question is where is that sense of belonging? Where is that sense of collectivism being promoted in the coming generations, so that there is a belief that to have healthy, resilient communities, we need to look out for each other. And in some cases, that's expressed through financial participation. In some cases, it's expressed through volunteerism, whether that's formal or informal. But it's a way of thinking about building strong communities. And so those are some of the things we're looking at for 2025.
Bruce, those are really good comments. The tradition that faith communities have had in instilling a sense of community, of thinking of others, because they're thinking of the relationship with God, but they're thinking of others on a horizontal basis, has really been a bedrock for Canadian society over the years. And we look at a lot of the institutions we have, educational, healthcare, and so forth, and they emanated out of faith communities making a difference. And your point's well taken, because as there is a decline in faith communities, it's hard to establish that sense of commitment to a greater good, to a community. And instead, it's all about me. It's my concern is what's important, as opposed to what the greater good is. So I think those are good observations and trends that are happening.
Well, and certainly, Terry, when we talk to philanthropists, they often say they learn the value, not the numerical amount, but the social value of giving at a place of worship. They watched their parents participate. They themselves, as young people, were invited to participate. So your point's bang on. And this is something that we sort of say, well, where's the future? Where are these future conversations taking place? Where is that social value connecting with young people, and not just the current generation of young people, but the future generations of young people?
Absolutely. We need to inculcate principles for the new generation on giving community first. And you can get that by in different ways, but certainly from faith communities can make a huge difference. And so we want to encourage and celebrate that. Thank you for that, Bruce. A couple of more questions. There's one more question for you. Imagine Canada has been doing some consumer polling recently, as I understand it. Are there any findings that you are finding hopeful?
Yeah, it's great because sometimes we talk about the data and it can feel a bit grim. And so what's great is we are seeing points of light in some of the data. Next week, we're actually coming out with a report that surveyed almost 3,100 newcomers to Canada. And as we think about the future of community and the fact that we are a nation that currently has the highest percentage of people who were not born in this country living in this country since Confederation, it is important that causes are thinking about how they're evolving. And what we're finding in this report is really stories of hope of individuals who are coming to this country with something like 70% or 60% are giving here in Canada, and a similar number giving overseas, people of Canada and the globe, and really seriously looking to engage authentically in their new communities. In addition, we've done some polling on companies and causes, and there's a new blog out this week with some of the data. One of the findings that I found particularly interesting was that 58% of respondents were saying they're looking at a company's practice in terms of supporting communities before they apply to a job.
Hmm.
That's risen 8 points since 2019. And so this idea that companies who have been very generous for many years, we're seeing their employee base wanting to have values that align with their personal values and the company values. And I think that's good news as we think about more and more companies being strategic and thoughtful about engaging in their communities. And the last point I'll mention is just around this classic cost of administration or cost of fundraising debate that's been going on for 30 years. We did some polling earlier this year, and one data point out of it. We gave Canadians 15 cost centers, listed them, and said, what's reasonable for charities to spend money on to deliver impact? And much to our surprise, at 78%, fundraising came in first, followed by technology at 77, followed closely by insurance, financial audits, and volunteer management. And what was even more shocking and delightfully surprising was that we'd also asked Canadians, how important they view the services of the sector. And 81% of respondents said they view the services provided by charities as essential to the well-being of their communities. When you cross-tab those two, that 78% support of fundraising rose 8 points. They all rose almost 8 points. There is widespread growing support, we believe, and maybe part of it's this data privacy stuff, we're not sure, and we're going to go exploring, that organizations need to have decently and fairly paid staff and the services and the infrastructure necessary to deliver quality programs. So there's light I think at the end of the tunnel, and we're hoping to work to start a new conversation with Canadians around how they think about investing in the causes they care most about.
Bruce, thank you so much for that. The philanthropic sector, the not-for-profit sector, the volunteer sector, whatever we want to call it, that to me is the heart of what we are as Canadians. And it is so important that it be encouraged and developed. And thank you for the work that Imagine does. Thank you for the work as well. So many charities on this call and umbrella organizations. Think of the 4Cs and others that do excellent work in encouraging the charitable efforts and not-for-profit efforts. So we're now so thank you, Bruce. You were wonderful by the fire. It was all great. Thank you very much, Bruce. We're now going to go into the coffee break, and that's going to give us 15 minutes. We're back on next presentation at 11:15. But if you're interested in jokes, apparently CEPO is going to permit me to do so at 10:10, if I remember correctly. So have a good break, and we'll see you back at 10:10 for jokes, or 11:10 for jokes, 11:15 for presentations. Thanks very much.
Okay, welcome back, everyone. I hope you had a chance to grab some coffee and refuel. But you know what they say, laughter provides the best energy, and we have just the remedy for you. Ladies and gentlemen, brace yourselves because we've got Terry ready to tell some hilarious jokes. So get comfortable and get ready to laugh because our resident comedian is about to take the stage. Take it away, Terry.
Wow, that's great, CEPO. Thank you for the introduction. I'm really impressed. That's a high bar to meet. So, as some of you may know, I do enjoy telling a few jokes. They're not normally very good. I do have a whole team Everyone in the office helps to provide some decent jokes because I picked some poor ones. So these ones are for sure to be pretty good. Why are penguins so awkward? They find it difficult to break the ice. When I was young, I dreamed of becoming a banker. However, as I got older, I kept losing interest. I don't trust theirs. They're always up to something. How does NASA organize a party? They plan it. Get it? Plan it. How much do pirates donate on average? A buccaneer. Where do sheep go on vacation? The Bahamas. Okay. What kind of tree fits in your hand? A palm tree. What do nuclear scientists eat for lunch in England? Fish and chips. Fish, fusion fish. What did the buffalo say to his son when he dropped him off at the daycare? Bye, son. Bye, son. Did you hear about the man who sued an airline company after it lost his luggage? Sadly, he lost his case. I tell these to my grandchildren. They think they're great. Why is dark spelled with a K and not a C? Because you can't see in the dark. What do you call a moose with no name? Animus. I burned my Hawaiian pizza today. I should have cooked it on aloha temperature. Aloha temperature. Okay, what did the left eye say to the right eye? Between us, something smells. Lawyers, here's some lawyer jokes. Lawyers really take the fun out of everything. Even Santa comes with a clause. Why are state lawyers the most determined? Because, quote, where there's a will, there's a way. Okay, a few more. I got a few more here. Why does a seagull fly over the sea? Because if it flew over the bay, it would be a bagel. A bagel. Why didn't the sun go to school? Because it already has 1,000,000 degrees. I got one more minute. Why are chemists great at solving problems? Because they have all the solutions. And then my final one. Did you hear about the cheese factory that exploded in France? There was nothing left but debris. debris cheese. Okay, there you go. So now I feel a lot better. I'm not sure whether anyone else does, but it was good. It was my therapy for the year. So thank you for being patient with me and not tuning out. Now back to actually substantive discussions. We're going to turn it over to Teresa Mann, a partner here in the Orangeville office, partner for many years and exclusively in charities area. And Teresa is going to be talking about the really exciting topic of understanding new changes to the T3010 charity return. Over to you, Teresa.
Thank you, Terry. And also thank you for the reminder that I've been a partner for many years. I feel like I'm fixture to the firm. Talk about jokes. I can tell jokes too. So the next 19 minutes or so, I'll be talking about new changes to a wonderfully important form that all registered charities would have to fill out and send to CRA within a certain time limit. And it's called the T3010. This form is for registered charities. So for those of you with us this morning, if this form is not applicable to non-charities such as non-profit organizations. So a bit of an overview. The T3010 is not just a tax return for accountants to fill out. It actually has information and questions that relates to whether the charity is in compliance with many rules in the Income Tax Act and also CRA's policies, such as give to non-qualified donees, fundraising, information about restricted gift and also impact investing. Now that the CRA is wanting charities to report in the T3010, many parts of the T3010 is public information. You can access that on CRA's online database for charities. There are certain information that is confidential, but the majority of it is publicly available. So for the next few minutes, I will give a very brief overview and orientation about the T3010, what it is about, the various sections of it. And then I want to talk about a few key changes of the T3010 that was implemented earlier this year. So a bit of an orientation. There'll be 5 topics that I will talk about. First of all, a complete T3010 filing would include the following things. There's the T3010 form itself. I'm going to call it T3010 proper. It has 6 sections. And then attached to the T3010 proper, the 6 sections, there are 7 schedules. Schedule 1, 2, 3, 4, 5, 6, and then 8. So $1 million question, where is Schedule 7? So think about it, and then I'm going to come back and give you the answer. Maybe if you get the right answer, it may qualify you for the wonderful draw at the end of the webinar this morning. So stay tuned. And then in addition to the form and also the 7 schedules, there are additional 4 forms available. Some of it is mandatory, like the first one, filling out details about directors and trustees of the charity. And the other 3 forms would need to be filled out depending on the response in the T3010. So I've taken screenshots of the form. For me, is high IT for me to be able to clip the form and put it on the slide. So I won't go through the screenshot in detail, but I put the screenshot there so that when you have nothing to do tonight, when you pull up my PowerPoint, you can actually compare what section I'm talking about. Section A is a little bit about identification of the charity, the name, the return year, and section B is about directors' information of the charity, and that's when every charity would need to fill out the T1235 on information about the directors. And then section C is about programming. Section D is about financial information. Note that section D in the form is only for charities that has smaller charities. But if the charity meets any one of the sub-bullets, then instead of filling out section D, it would need to fill out Schedule 6 instead and provide a lot more detailed financial information. So the criteria is on the slide. I'm not going to go through it in detail. Section E is certification for the charity, someone as a rep to certify that information in the form is accurate. Section F is confidential data about where the charity keeps its books and records and the name of the person who completed the return. Now, this is a more detailed listing of the 7 schedules. Again, I will not go through it in detail, but again, there's no Schedule 7. And why? If you pay attention to the Fireside chat, there was some mention about the PPDDA way back when, a few years ago, which is the Public Policy Dialogue and Development Activities, PPDDA. When the policy first came out, charities were actually required to fill out information about the PPDDA, and that's Schedule 7, and that was scrapped together with some questions in the T3010 about PPDDA. So that's the $1 million question. When to file the T3010? T3010 must be filed within 6 months after the fiscal year end, no exception. And the effective date of filing depends on how the form is filed. If it is filed online, then the effective date of filing is when you click submit. If you send it by mail, and that will be the postmark date on the envelope. If it is hand delivered, like courier, then it'll be CRA receipt stamp. Failure to file the T3010 may lead to revocation of the charitable status. So if T3010 does not file within 6 months, CRA will send you reminders, send you letters. After a certain trials and no response, CRA will send an ultimate notice called T2051A, which is a notice that charity has 90 days to file. If it's still not filed, then finally there will be a notice of revocation. And once that notice is sent and status is revoked, that's the end of it. If status is revoked, then it can no longer issue donation receipt. It's no longer exempt from income tax. Charities can reapply for registration after losing charitable status, but the thing to remember is the re-registration is not guaranteed because it would have to file a complete registration application just like everybody else. And there are some tips for completing and filing the T3010. Make sure that you review the guide to T4033, a very, very helpful information. Keep track of the filing, keep a copy of the form for records. Now, the key portion about my presentation is make sure that the right form is filed. The form is updated every year. Previously, there was a T3010 version 23 for prior fiscal year end. And then for fiscal year ended December 31, 2023, charities would have to file a new version 24. Version 24 was released in January 2024. Now is November. 2025 is coming. I've just checked CRA's website. There's no new version released yet. I would suspect that for fiscal year ended December 31, 2024, there might be a new version 25. So for charities, when you plan, by the time you are ready to file the T3010 for fiscal year ended December 31, 2024 and forward, make sure that you check CRA's website and get the updated form. So this is a bullet list of new changes, the new information included in version 24. I will highlight a few of those because some of them are just brand new questions and information that is needed. So these are the 5 that I want to talk about. First of all, there's a brand new questions asking charities to report to CRA in the form about donor advised funds held by the charity, called the DAF, donor advised fund. So what is donor advised fund? According to CRA, if the guide, the T4033, it says DAF means a fund segregated into donor accounts owned and controlled by a charity. Each account comprises of donations by individual donors. Donors may provide non-binding suggestions on payouts from DAF. So pay attention to the lines that I've underlined. So there are 4 lines. Basically, what it means is at the end of the fiscal period that you're reporting, you need to report the total number of DAF held by the charity and the total value of those DAF held by the charity. And then it will also require you to fill out how much donation received by the charity and got put into the DAF. So how much you got from this fiscal year, and then how the total value of gifts to QDs and grants to non-QDs made from DAF. So pay attention. You only need to report payouts from the DAF, gift to QDs, and grants to non-QDs, but not disbursements of the DAF on charitable activities carried out by the charity itself. So there are a bit of a concern, and more like a question. The meaning of CRAs about DAF is is narrower than what DEF really means. DEF at law can mean donor providing advice on various aspects of the fund. It's not just about payouts, but CRA's definition for the T3010 is only DEF where donor provide suggestions on payouts. So what is required to fill out in the T3010 is a subset of what DEF is really about. So then the next question is, do charities have the necessary information to weed out the many DEF accounts that it held and then draw out those that are required to be reported in the T3010? Maybe a bit of an exercise for charities in order to fill out the correctly information required by CRA. And at the bottom, I provided a link to a really wonderful presentation by a colleague, Jackie Damshire, on what DEF is about. The second thing that I want to talk about is the new version 24 has a few questions that require charities to fill out restricted funds held by foundations. So the reporting on restricted funds is only required by foundations, not charitable organizations. There are two different definitions about restricted funds that I can find. I went to CRA's glossary. If you Google CRA charity glossary, then you will pull up a whole bit long list of glossary where CRA define terms. And the definition is here on the slide. I'm not going to go through it in detail, but I just want to highlight a few things. In the glossary, it says restricted funds are funds tied to a specific use, not for general purpose. And then in the guide T40 Series 33, it defines restricted funds to be funds where a funder, including a donor, grantor, lender, or payer, limits how the funds can be spent. Okay, so the two are not exactly the same, talk about different things, and they both want to define what restricted funds means. There's a line in 4170 in Schedule 6 that require charity to report the value of asset held, which would include restricted funds, nothing specific about specific funds. But then for foundations, there's a new question in Schedule 1. Schedule 1 is only for foundations, that it will need to report on total value of all restricted funds held at the end of the fiscal period, and then how much of the fund that the charity is not legally permitted to spend. So that means restricted funds is funds that is restricted to a payout. There's one thing. The other one is it means funds that a charity would have to can only spend income, not capital. So a bit of a question. Meaning of restricted funds is much broader than the specific use and how funds can be spent as defined by CRA. And in the first presentation that Jackie and Ryan talked about, there's a few slides on what restricted funds means. Donor can impose restriction on many aspects of a fund, including use, time, and or management. So what CRA wants is a very small subset of restricted fund. And also, if you notice the wording, restricted funds from CRA's perspective for purpose of the T3010 are restricted funds imposed by donor, grantor, lender, or payer. So, but then in the first presentation, the charity board itself can restrict a fund. So for internally restricted funds by the board itself, it seems that it's not captured by what CRA requires in the T3010. So bit of, make sure that you keep that in mind. The third thing that I want to briefly talk about is tracking disbursement quota. Disbursement quota is the minimum amount that a charity would have to spend on its charitable activities or making qualifying disbursements. So what it is, you calculate the asset base that a charity is not using for its administration or activities. Then you apply a 3.5 or 5% on it, and that's the obligation that they have to spend. the T3010 version 24 contains a new Schedule 8 on tracking disbursement quota. So this slide briefly talked about the two line 5900 and 5910 that has always been there, that charities would have to fill out the asset-based calculation in order to calculate how much the DQ would have to spend in the reporting fiscal, and then also calculate the asset base that the charity would need to estimate how much it would need to spend in the following fiscal year. And this slide briefly talked about if a charity would have to is subject to the DQ, then it would have to fill out Schedule 8, which goes into detailed calculation. And this is what Schedule 8 is about. A bit of a highlight of the schedule and the calculation. There's also new information about reporting on making grants, qualifying disbursements. In the previous version of the T3010, there's already some questions there, but in the version 24, there's some minor updates on the reporting requirements. So basically, if a charity spends less than a total of $5,000 in making grants to non-qualified non-QDs, then you only need to fill in information in the T3010. But if the charity spends more than $5,000 in grants to non-QDs, then you will need to fill out T1441. So the next couple of slides explains the information required in the T3010 and also 1441. And then the last thing that I want to highlight is there's a new question that charities will have to fill out about impact investing. This is completely brand new. Charities have to report all impact investments and also the income, the return made from the impact investments. What I want to highlight is CRA explains that impact investments for purpose of the T3010 means investments made with the intention of a positive environmental or social impact and generating a positive financial return. However, for charities that are in Ontario, there's a thing called social investment under the Charities Accounting Act, and under that act, making a return is not required. So it might be a bit of a confusing, like schizophrenic for charities in Ontario that make social investments versus impact investments and what is qualified for T3010. So a bit of a thing that charities will need to be aware of. So finally, just a bit of a conclusion, T3010 is complicated. It's not just a tax form. It relates to many aspects showing compliance with CRA requirements. So I know I have many clients that leave the T3010 to the auditor to fill out, just fine. They can do a first cut. But then charities itself, senior management, including the board, should take a closer look at the T3010 and make sure that information is complete and accurate, and do it early and don't leave it until the last minute, and seek professional advice if there are any questions.
Okay, thank you very much, Teresa, for being very informative and entertaining year after year after year. That was great. Next up, we have Esther O, a partner from our Orangeville office, and Urshita Grover, an associate from our Orangeville office. They'll be guiding you through the topic of remuneration of directors of charities in Ontario, what is allowed and what's not. Over to you.
Thank you, CPAL, and good morning, everyone. As CPAL mentioned, Esther and I will be speaking on remuneration of directors of charities. To provide a quick overview, we will start off by providing some context, followed by requirements in the regulation and other considerations. We will also go over some fact patterns and end off with the key takeaways. To provide some background information, according to common law, directors of registered charities cannot receive direct or indirect remuneration from the charity unless authorized by a court order or a Section 13 consent order. A charity may apply to obtain a Section 13 order upon written consent from the PGT to be exempted from the prohibition on remuneration to a director without having to commence formal court proceedings. While this option is faster and cheaper than a court application, the PGT would not likely agree to the Section 13 consent order unless there are exceptional circumstances underlying the request. While the common law prohibition prevents payment to directors, it does not prevent directors from being reimbursed their out-of-pocket expenses. The common law continues to apply, but the regulation under CAA was amended in April 2018 to authorize payments to a director or a person connected to a director without obtaining a court order or a Section 13 consent order. All applicable requirements in the regulation and associated guidance document by the PGT must first be met, as will be explained in further detail during the presentation. Next slide, please. This presentation provides a brief overview of the considerations that a charities board should review before approving a payment and other key requirements in the regulation and guidance, because while most charities are aware of the regulation and guidance, there is not always a clear understanding of the steps to be taken to comply with legal requirements. The second part of this presentation will review some case studies inspired by real-life examples to help guide charities and their boards. We have also provided additional research materials at the end of the presentation. Presented here on slide 5 is an overview of the key requirements in the regulation, starting with application to incorporated charities. The regulation states that a corporate trustee may make payments from the charitable property acquired by it to a director or a person connected to a director of the corporate trustee for goods, services, or facilities provided to it. The CAA deems all corporations incorporated for a religious, educational, charitable, or public purpose to be trustees within the meaning of the Act. As such, the regulation cannot be used to pay trustees of charitable trusts or non-incorporated charitable organizations. The guidance uses the term charitable corporations instead of corporate trustee, and for the purposes of this presentation, we use the term charity for an incorporated charity. This presentation also uses directors to describe the governing board, even though members of the governing board may be referred to as stewards, elders, governors, or another term. Slide 6 includes the list of persons connected to a director under the regulation, which are referred to as connected persons in the guidance, and these include a child, parent, grandparent, sibling, or spouse of the director, which we collectively refer to as a family member, and the use of the word including in the guidance suggests other family members than the ones listed might be considered a family member under the regulation. Other connected persons include employer of the director or of a family member. A corporation in circumstances such as ownership of no more than 5% of shares or 20% of the voting shares by the director or family member, or a corporation where the person acts as a director or officer. Finally, any partner or partnership connected to a director, family member, or a corporation connected to a director. For further details on connected persons, please refer to the regulation and guidance. Esther, over to you.
Thanks, Rashida. Now on slide 7, it lists the payments that are not permitted under the regulation. Payments to a director to serve in the capacity of a director, payment to a director to serve as an employee of the charity, direct or indirect payments to provide fundraising services or for the sale of goods or services for fundraising purposes, and direct or indirect payment made in connection to the purchase or sale of real property. And the phrase in connection to is very broad. So this means a charity cannot rely on the provisions in the regulation to make payments listed on slide 7 under any circumstances. Only time they would be legally authorized is when the charity has obtained a court order or a Section 13 consent order, which Rashida mentioned at the beginning of the presentation. Next slide, please. Now, before a charities board approves a payment under the regulation, The board must review the considerations listed on slide 8 to confirm it would be in the charity's best interests. The amount is a reasonable amount to pay for the goods, services, or facilities, whatever is being provided. The payment would not result in the charity's debts being greater than the charity's assets or render it insolvent. And in most cases, this particular consideration would not apply. And the payment must not exceed the maximum amount set out in an agreement. While most charities are very diligent about reviewing whether a proposed payment would be in the charity's best interest and making sure the amount is a reasonable amount, many charities unintentionally omit altogether the requirement to enter into an agreement. I'll now review a few issues relating to that. Next slide, please. Once a charity's board has determined that the proposed payment can be made under the regulation, then the charity's board needs to prepare a written agreement which contains, at a minimum, the items listed in the regulation and guidance. There are other provisions which can be helpful to include into the agreement, but this would depend on the circumstances. Under the guidance, the agreement should include confirmation that every director agrees to the maximum amount payable. And if the proposed payment involves a connected person, that person must also agree. Every director must agree that they are satisfied the payment is being made in accordance with the requirements and restrictions of the regulation, and a statement confirming that the board considered any other requirements that might apply from the guidance should be added as well. Next slide, please. Other requirements under the regulation include there must be at least 4 directors on the board, and this is excluding the director who has a conflict of interest because they're either receiving the payment or is connected to the connected person who will receive the payment. The total number of persons receiving payment must not exceed 20% of the number of directors, again, excluding the director with the conflict of interest. The director with the conflict must not attend or participate in the board discussions regarding the matter, and they should obviously not vote either. And the fact that the director with the conflict of interest left the room, didn't participate or vote should all be clearly recorded in the board minutes. If your charity is audited or if a complaint was made to the PGT, you need evidence that these steps were taken, and these should be kept in the charity's corporate records. Next slide, please. Another requirement that is commonly omitted unintentionally is that the payment must be noted in the charity's financial statements for that year and presented to the members at an AGM. The guidance states how to describe the payment in the financial statements and even provides sample wording that can be used. So reference can be made to the guidance for further information on that. If several years down the road, there's an allegation the board failed to meet its legal obligations under the regulation and guidance, and the matter was legally reviewed by a court or the PGT, there is a risk the directors could be found in breach of their fiduciary duties and might even be liable, which means responsible, to repay the funds out of their personal funds on a joint and several basis. And again, this is why we keep underscoring it's very important to document all of the due diligence steps being taken by the board to comply with the regulation and guidance and keep those records as evidence. On slide 12, there are legal requirements which may apply to direct payments to directors from other sources other than the regulation and guidance. I won't go over those in the interest of time. Slide 13. Now, in the second half of this presentation, Urshita and I are going to review some case studies to help walk you through the steps and the analysis required under the regulation and the guidance. The following are fictional and do not depict any actual person or event. So, case study number 1. A director of a registered charity has a long history with the charity and dedicates a significant amounts of their personal time and service to the organization. The person also has very specialized skills and knowledge, which the charity needs. The board feels it would be in the best interests of the organization to hire this person as a paid employee, but at the same time, they don't want to lose this person as a valuable board member. If the board approves the decision by majority resolution, can this director become a paid employee of the charity? Urshita, we look forward to your comments on this.
Thank you, Esther. The regulation does not authorize remuneration or payment for services provided by a director as an employee of the corporate trustee. As such, the director of the charity cannot also become a paid employee of the charity under the regulation, and approval by a court order or a Section 13 consent order will be required. Alternatively, the director may resign from the board and become a paid employee. The fact scenario for our next case study is as follows. A director's sibling owns a small restaurant that is incorporated and wholly owned by the director's sibling, who wants to provide meals on a weekly basis to support the charity's programs to assist individuals experiencing food insecurity. In return, the director's sibling only wants to be reimbursed for the cost of the food, which is far below fair market value. The board feels that this would be in the best interest of the charity. Esther, what are your thoughts on whether or not this is permitted under the regulation and guidance?
Thanks, Rashida. So, under the regulation, the definition of persons connected to a director, which we during this presentation and the guidance are referring to as connected persons, includes a business that is wholly owned by a family member of a director. So now that we have identified the proposed payment is to a connected person, we will next need to go over the other considerations and steps to be reviewed by the charity. Next slide, please. So first, the board needs to determine the proposed payment would be in the best interest of the charity, as described in further detail in Section 8 of the guidance. This involves a detailed analysis of the circumstances because it's really a question of fact, whether or not the proposed payments would be in the best interest of the charity. The guidance lists the criteria to be reviewed, including whether the goods, service, or facility would be beneficial to the organization, whether there's an advantage to the charity in using the services of the director or connected person over hiring someone else. In our fact scenario, the restaurant owned by the director's sibling has offered to provide services at less than fair market value. So this is obviously a financial advantage to the charity since it's cheaper than what they would normally pay for the food. Other requirements in the guidance would also need to be reviewed. If the charity's board determines that the proposed arrangement is in the charity's best interests, the board will need to determine a payment amount that is reasonable by reviewing several considerations, including, again, the market price for similar goods, services, or facilities in similar circumstances, and the value to the charity of the goods, services, or facilities. Next slide. As I mentioned earlier in the presentation, once a decision has been made to move forward, an agreement needs to be prepared confirming the specific requirements in the guidance, including the maximum payment amount, which every director and the connected person must agree to, confirmation by every director that they're satisfied the payment is being made in accordance with the requirements and restrictions of the regulation, and that they've considered other requirements under the guidance. Once the maximum amount has been in the initial agreement has been fully paid, an amendment to the agreement will be needed before any other payments can be given. Other requirements set out in the slide and the guidance would also need to be met. Next slide.
Thank you, Esther. In the next case scenario, a director wants to donate some land to a charity, and the land's location is ideal to support the charity's expansion of charitable programs. And the board believes that it is in the best interest of the charity to receive the land. While the director does not want any payment for the land, he does want money to pay for costs to remove the director's heavy equipment from the property to the director's home. Esther, do you think the charity can pay the director's requested costs?
Thanks, Rashida. So again, the analysis very much depends on the facts. In this particular example, the land is worth around $200,000, and it would cost roughly $10,000 to make arrangements to move the several pieces of heavy equipment from the property. Even though the director is saying they want to donate the land, it's not a gift without consideration. It's a gift with consideration because in this case, there's a requirement for a monetary payment by the charity in order to receive the land, and that payment is directly connected to the transfer of the property to the charity. This would therefore likely be considered a payment made in connection with a purchase and sale of real property transaction. Therefore, it would most likely not be permitted unless the charity obtains a court order or a Section 13 consent order, although in this case, it would not be practical. Next slide. So moving on to case study number 4. The CEO, who is a paid employee of a charity, has a daughter who has the educational and professional experience the charity needs for the expansion of its programs. The board believes it would be in the best interest of the charity to hire her. Can the CEO's daughter become a paid employee of the charity? Urshida, would you please share your comments on this one?
Thank you, Esther. The regulation and guidance apply to proposed payments to directors and connected persons. However, the CEO is not a director and therefore no common law prohibitions apply. As such, the CEO's daughter can become a paid employee of the charity. While the CEO normally attends and participates at board meetings, he or she should not participate in board discussions regarding the proposed employment of his or her daughter. And as Esther mentioned previously, this should also be recorded in the minutes of the board meeting.
Great. Thank you very much, Rashida. So to sum up the key takeaways, if a charity wants to authorize a payment to a director or a person connected to a director, it's important to be aware there are options under the regulation which do not require a court order or consent order. Then the charity should review the regulation and guidance to confirm whether the proposed payment is, first of all, to a director or a connected person as defined in the regulation. After that, a charity will need to carefully review whether the proposed payment is permitted under the regulation and guidance or not. If it is, it's very important to comply with each of the requirements and document this in the charity's records. When in doubt, charities can speak with their lawyers. We've provided links to a few resource materials on the final slide, which can be reviewed for more information at a later time. And that concludes our presentation.
Okay, thank you very much, Esther and Urshida. That was great, very informative. Next, we have our managing partner, Terry Carter, speaking on a very important topic, charities working with non-charities. What are the options? Over to you, Terry.
Well, that's great. I just want to make sure my slides are going to advance, and I'm just going to do a little control. I should have control, and it should advance. There. Wonderful. Okay, well, this topic is an important one for charities. A lot of charities are wondering what it is that they can do with regards to working with non-charities. And so we're going to be talking about a number of different issues. What do we mean by non-charity? What are the options of working with a non-charity, an unqualified donee? And then we're going to spend a bit more time on two options, the own activity regime option, as well as the qualifying disbursement regime option. And then at the end, I'm going to spend a bit of time on doing a bit of a scorecard comparison between the two, because a lot of organizations wonder which way they should go. So when we're putting things into sort of context and we're thinking about a registered charity, registered charities work with non-charities all the time. They have to acquire goods and services or professional services from their accountants or their lawyers. There's no issue with charities getting the services that are needed, provided that the cost of those services are not above fair market value, and assist the charity in moving forward with achieving its charitable purpose. Things become a bit more difficult when the charity is working with a non-charity in order for the non-charity to deliver charitable programs and activities of the charity. So that's really the focus of our discussion today as we go through it. In the event that you're a bear for punishment and you like to go into more technical aspects, we have done a number of publications as well as previous PowerPoint presentations. They're all listed there for you in case you wanted to get some more details. What I'm going to be doing today is very high level, just kind of an overview sketch to kind of put things into kind of a big picture for you. And then you can come back at a later time and drill a bit deeper as needed. So when we talk about a non-charity, at least for this presentation, we're talking about an organization, whether it be located inside or outside of Canada, that's assisting the registered charity in working with and achieving its charitable purposes. But the organization is not a charity, and the organization is not a qualified donee. What do we mean by qualified donee? Well, that's a list of entities under the Income Tax Act that's a very important list. And it permits charities to make gifts over to other qualified donees as a matter of basic right that they have under the Income Tax Act. What's a qualified donee? Well, I've set out here a whole list from the Income Tax Act, and it's a long list. The ones that you'd probably be the most interested in would be working with, for instance, municipalities. All of them in Canada are registered at this point, or maybe working with a registered university outside of Canada, where a large student body ordinarily has students from Canada in it. And of course, registered charities right up at the top are the most significant part of the group of qualified donees. So when we're talking about entities which are non-charities, we're really talking about non-qualified donees to be on the technically correct standpoint. They're really interchangeable between non-charities and non-qualified donees. For the balance of the presentation, we'll refer to non-qualified donees to be in sync with the Income Tax Act. Okay, you got a charity that wants to deliver charitable programs and activities, but it has to work through an organization that's not another registered charity, not another qualified donee. There really are only two main options, number 3 and 4. Number 3 is dealing with activities on activities, and number 4, which I'll explain, is the qualifying disbursement. But there are a few others as well, and I've sort of listed them there as number 1 and 2, which I'll explain in a little bit of detail, but they're not all that relevant to what most charities deal with. And so under option number 1, this is where an unqualified donee is an intended recipient of the charity's charitable program. And I've given you a link to some of the guidances that Canada Revenue Agency has put out. One deals with community economic development, and it points out that it is possible for charities to provide support for non-qualified donees in certain situations. One would be if the non-qualified donee is promoting commerce or a particular industry or trade, such as an agricultural industry or agricultural fair. Another example is where you're dealing with improving the socioeconomic conditions, a public benefit, the event of a economic deprivation, including disasters. So this could include, for instance, restoring local businesses, small businesses, after a natural disaster under certain terms and conditions. Local business is not a charity. It's a non-charity, but in that limited context would have application. Another situation that's referred to in a guidance put up by CRA dealing with umbrella organizations. It's not well known, but it's the second type of umbrella organization where it's possible to fund non-charitable entities, and I'm just going to read from it because you got to be very exact on it, with the provision of services that are narrowly focused on increasing, enhancing, or improving the non-charitable activities, services to charitable beneficiaries. Bit of a mouthful, but it does have some limited application. So it's good to know what is available in relation to option number one. Option number two is where a charity wants to go out and work with a non-qualified donee to achieve a particular charitable purpose. Think of a research charity that wants to get research done. They'll contract with a researcher. Researcher's not a qualified donee, it's not a registered charity. And there will be a contract entered into to have the researcher undertake a particular project under a research grant. Another example would be an educational charity having an education grant to develop new curriculum content. In these situations, there's a contract in place, there's an end goal, which is to develop these particular end products to achieve the charitable purpose. But the charity is not sort of hovering over the researcher or the content developer. Instead, it's really a contractual relationship to obtain the end product that is required. So that's why I refer to it as non-qualified donees producing a deliverable under contract to achieve a charitable purpose. It's not the same thing as the other options, which I'm going to talk about now. Number three option is the one that's been around for years, where a charity is conducting its own activities through an intermediary under the direction and control regime. And here, just think about it, that a charity can carry out its activities with its staff, with its board, with its volunteers. And in addition to that, it can work with third-party intermediaries, provided that the intermediaries are working under the direction and control, like an extension of the charity. So it's not a gift over, it's an extension payment over to a third-party intermediary in that context. We'll talk about that more in a minute. And then the fourth option is the new one that's come up as a result of our guest speaker, Senator Omidvar, was responsible for moving this forward. It's the idea of making a gift or making resources available over to a non-charity in order to achieve the charitable purpose of the charity in question. And CRA refers to it as a grant. It doesn't always line up with how the term grant is used, but that's the terminology that's used. But it does require a great deal of accountability requirements to be met. And I'll talk about that a bit in a minute. And then the option number three that I made reference to, the own activities, I wanted to give you some resources in the event that you want to do your own comparison. CRA does have guidances up for own activities through intermediaries under direction and control outside of Canada as well as inside of Canada. The key aspect of all of this, of course, is that it must be an activity that's done through the third party under the direction and control of the Canadian charity. And so when we're looking at what sort of documentation that's required, you have to do the due diligence that's necessary, make sure that there is a checking out of the party that you're dealing with, make sure they have the capacity to be able to follow through. And then you need to have an agreement provided that the resources of the money you're providing exceed $5,000. The type of agreement that you would have would depend upon the type of relationship that you have. It either could be an agent, a contractor, a joint venture participant, cooperative participant, are some of the examples that CRA provides. When you do the agreement, I've listed on this slide a number of factors that you need to take into account: setting up the activity, getting reporting back, periodic transfers, making sure that you have sufficient books and records. So it's been around for many, many years. It's a bit onerous at times, and some of the challenges that the sector has identified with the own activity regime are listed here. One is it tends to be a legal fiction because the transfer of funds and resources are not really intended to be received by the recipient as an extension of the charity. That's a bit of a legal fiction. Instead, they see it more as the Canadian charity funding them, and they don't always understand why there is this requirement for direction and control. And that leads to concerns about sort of a paternalistic concept, particularly when you're working with Indigenous and majority world communities. It's not the right tone that you want to be able to communicate. And similarly, particularly in the international context, the idea of subsidiarity means you try to get things done most efficiently at the local level. You don't particularly want to have the Canadian charity telling you what to do. You're supposed to leave it up to the local party or partners in order to make those determinations. And the other factor is it's very much out of sync with what happens in the US and in the UK with the Charities Commission. So Canada has been out of step. As a result, again, through the work of Senator Omidvar pushing finance to move forward with the changes, changes did happen in back in 2022, June of 2022. And it's now possible through the concept of a qualifying disbursement regime for charities to make gifts, not payments over to third parties, but gifts to third parties, as well as making other resources available in order to assist the recipient. But it has to be tied into achieving the charitable purpose of the charity, the Canadian charity, as well as all of its activities that are being carried out through the qualifying disbursement are exclusively applied to charitable activities in furtherance of the charitable purpose of the charity. And then you have to have, as number 3, sufficient documentation to be able to identify all of that and be able to prove that in the event of an audit. CRA did come out with a guidance. They had a draft earlier back in 22, but their final version came out in December of 23. Give you a link to it up here. CRA has taken the legislation and they consider the steps that are required. Number 1, you establish how the grant furthers the purpose. Number 2, you assess the risk associated with doing that grant. Number 3, you determine the type of accountability requirements that will be necessary. Number 4, you apply the accountability tools in collaboration with the recipient of the grantee organization. And number 5, you make sure that you've documented it with proper books and records. When it comes to the accountability requirements, this is actually a slide that CRA had prepared at one of their earlier seminars. I thought it's a good slide, showing accountability tools in the center and it indicating that you have to be able to research and review the grant, and then you have to have a description of the grant activity, and then a written agreement and reporting plan and transfer schedule and separately track funds. It's quite extensive when you go through the guidance. And even though you don't have to have an agreement below non-recurring grants of $5,000, the details that need to go into the grant agreement are fairly significant. This slide just provides a bit of a summary of materials that we've written on before, so I won't go into a lot of detail, but I just point out here that when we're looking at number 1, the terminology and the guidance isn't necessarily the same as what's contained within the Income Tax Act, so you got to be careful on that. Secondly, you got to make sure that whatever you're thinking of doing in the way of a grant, like a gift over to an unqualified donee, it ties into your purpose. Number three, if your charity is a foundation with just purposes to make gifts over to other qualified donees, it's not going to work as providing a sufficient charitable purpose to be able to do qualifying disbursements. So you may have to amend your purpose. Number four, the accountability tools are significant. Lots of reference to risk seems to be a real priority that CRA is on the area of risk, which is problematic. There's not a clear explanation of what otherwise making resources available includes, but generally speaking, it includes things such as making volunteers or space or backroom services available. Number six, some qualifying disbursements, such as otherwise making resources available, do not count towards your disbursement quota, so you need to be aware of that. And number seven, there is a provision that is an anti-directed giving provision, which can be problematic. We don't have time to go into the details on it, but if you take a look at some of the resource materials, we explain that in a bit more detail. In the last couple of minutes, I wanted to go over with you sort of a scorecard of comparisons between the own activity regime, option 3 on the left, and the qualifying disbursement regime, option number 4 on the right. Some things, qualifying disbursement is better. And so when it comes to the focus on the recipient's activities in number 1, it's good. Number 2, it's more of a collaborative relationship compared to own activities, so that's good. Number 3, it focuses on gifts being received so that the recipient, unqualified donee, can use it for their programs, provided it ties in to the programs of the charity that's making the grant. So that's good. When it comes to the mechanism for qualifying disbursements, it's primarily focused on a high degree of risk and accountability. It seems to be, I think, more onerous than what it needs to be. So I've given that sort of an X there. And then number 5 is the focus on documentation tends to be a bit easier with the old own activity regime than the details. And then on number 6, here we're talking about liability, and liability tends to be better with a qualifying disbursement regime because you're making a gift. Whereas with own activities, it's kind of an extension of yourself, and there's some exposure to liability because of that. Then number 7, here, if you're concerned about meeting disbursement quota, it'll be easier with own activities compared to some aspects of qualifying disbursements. And then number 8, if you're looking at buying property through a third party recipient, particularly outside of Canada, tends to be easier with a qualifying disbursement regime compared to that of the own activity regime. And number 9 is dealing with an HST issue. Generally, if you're doing work inside of Canada, it's easier to do a grant. There's no HST that applies to that, although in Canada for own activities, there may be, to talk to your HST counsel. And then number 10, basically on the reporting side, doing a comparison between the two, there's a fair bit on reporting that has to be done with the qualifying disbursement regime. So that's why I gave it an X. Not that I think that the T3010 for own activities is necessarily simple, but I think between the two, there's a bit of a comparison. So I wanted to give you that sort of chart just to have that available for you when you're looking at, which of these two regimes, 3 and 4, own activities, qualifying disbursement, you look at. Option number 1 and 2 are very specific. They're not going to come up that often. It's really just there for context. So hopefully the chart at the end will be of help to you and your organizations, but you do have to do the homework. You do have to read through the guidances. You do need to take a look at other commentators, have what they've had to say about it. You can take a look at some of the resource materials that we've provided as well, and hopefully that will be of help to you. So that's my presentation on charities working with non-charities. So thank you for your attention on that. Now we're going to go into the pièce de résistance for the program today. We're just absolutely delighted to have the retired Senator Omidvar with us and to be able to do a fireside chat. And just while I think she's getting her screen on, I'm going to just give a little bit of background for the senator. In April of 2016, Senator Omidvar, former Senator Omidvar, was appointed to the Senate of Canada as an independent senator representing Ontario. Senator Omidvar served as chair of the Standing Senate Committee on Social Affairs, Science and Technology, and as deputy chair of the Special Senate Committee on the Charitable Sector. In November of 2024, this year, she was appointed as a Public Policy Fellow on Immigration at the School of Public Policy and Democratic Innovation at Metropolitan Toronto University. Senator Omidvar was appointed to the Order of Ontario in 2005, became a member of the Order of Canada 2011, with both honors recognizing her advocacy work on behalf of immigrants and devoting to reducing inequality in Canada. And Senator Omidvar received an honorary degree, Doctors of Law, from Toronto Metropolitan University in 2018 and from York University in 2012. And in 2019, she received the Dr. Jane Mayer Global Citizenship Award from Tufts University. Senator, we are delighted to have you with us today. This is wonderful. You've been with us a few times before, and now to have this sort of the apex of your career as a senator with your recent retirement, we are very privileged to have you. You represent so much that's important for the charitable sector. So thank you for being with us.
Thank you so much, Terry, for having me. It's always a great pleasure to speak to you and to people who work in the sector, and I'm looking forward to our conversation.
Wonderful, wonderful. Well, Senator, I'm going to give you a couple of questions to give you some room to tell some stories and tell us what your thoughts are. So, first of all, please tell us what some of the accomplishments you're most proud of as a senator in your work with the charitable sector.
I'm trying to take a look at the big picture and not the particular steps. I think I'm proudest of accomplishing something that was partly accidental, which was to put charities on the map. And by that, I mean on the legislative map in Ottawa. It is very rare to see legislation focusing on charities come across our desks when I was a senator. And that's partly because, nobody really pays that much attention to the Income Tax Act, which is the font from which everything about charities flows. And it hasn't been reviewed, I believe, since the 1950s. So whatever changes have come in a piecemeal manner. And I did not set out when I was appointed to the Senate. It occurred to me that I had actually never worked for outside of the context of charities ever in my life in Canada. It's only when I became a senator that I stepped out of that sphere. And I thought when I went to Ottawa that I would focus mostly on the issues that I was engaged in: global affairs, human rights, social justice. But I came to realize that all these issues, human rights, global justice, social justice, most of the best ideas emanate from the civil society sector and mostly from registered charities. So, I sort of came to that conclusion after I was appointed by the Senate as vice chair of the Senate Special Charities Committee, which was, I think, struck in 2018. And we spent 2 years listening to expert witness testimony from all over Canada outside. I think, Terry, you appeared as well. And we came out with 42 recommendations. And we still, the Senate still stands behind those recommendations. And I picked up 2 of those recommendations and gave them legislative life through tabling legislation in the Senate. One of them, as you noted in your previous comments, was called into law. The other is still making its way through the chamber. So listeners may think 42 recommendations and only 2 legislative proposals. They may say that's not progress. Well, I have to say to everyone that legislation moves at a glacial pace. And so you pick off issues that are winnable, that are doable, that are pragmatic. And I think I contributed to that agenda in terms of charities. And I'm really proud of that. To get back to your question.
Senator, you've had an interest all your life in Canada in working with charities. Maybe you just tell us a little bit about what you did before you were in the Senate, because you say that you worked with charities. I think the audience would love to know what your work was.
Well, this is an interesting story. I came to Canada in 1981. Deepest, darkest recession, as we all know. There were no jobs. There was certainly no jobs for anyone without Canadian experience. So now we use other words, but those days it was actually, do you have Canadian work experience? So I couldn't get a job. And I started to volunteer at a local agency. And it was a charity. It was a local settlement house, very well respected in Toronto, St. Stephen's Community House. And the staff, they somehow seemed to like the energy. I was many years ago. I'm much older now. I still have some energy, but maybe not that much. So I was hired on to a special contract, and ever since then, I worked at St. Stephen's for about 5 years, 8 years. I moved to another agency. I created new charities. I sat on boards of charities. I moved to a philanthropic foundation, and then finally to a university. So, it's all been the charitable sector until I became a senator.
Working in the charitable sector, because the people on this Zoom webinar are involved, not all of them, but many of them. How did you find, from a bureaucratic standpoint, what your experience was in trying to, run a charity with all of the compliance issues? Did you ever think about that?
Well, I was eventually executive director and president of major charities. So you have to know the rules and you have to comply with them. And every now and then the CRA will come knocking on your door and they turn you inside out, upside down. But in the end, I think we have to recognize that the CRA progresses on non-compliance in a measured manner, mostly in a measured manner. So first, they'll come and talk to you, they'll take you upside down, they'll open your papers, then they'll perhaps issue you an administrative letter, and you sort of fix your systems, and then everything goes back to normal. I think you cannot work in charities without knowing the rules. And I fear that the rules are not well understood. They may be well understood by the leadership. I know for a fact that they're not completely understood by governance, and definitely not understood by the grassroots of the organization.
I think that's a fair comment. To be completely transparent, I find it tough trying to keep track of all of the rules. It is not easy to do. So I have a lot of sympathy for grassroots organizations that want to do good, but need to have charitable status, and there's just a steep hill that has to be climbed in order to do that.
Yeah, and I don't think every not-for-profit should become a charity. I think they should think really hard about it, because becoming a charity carries privileges, but it also carries a great amount of responsibility and accountability. One of the changes, I still sit on a couple of boards, although I'm slowly going to wean myself off. I don't know if the boards of directors of charities actually ever sign off on the T3010. And that's a problem.
I couldn't agree with you more. And Teresa made reference to it. It's often, farmed out to the accountant or sometimes to a staff person. And it's the public facing document for the organization to both the regulator as well as to the public.
Precisely. And in my experience, the executive director and the chartered accountant normally deal with this on a one-on-one basis. But I think, after all, what is the role of the directors of a charity? It is the fiduciary responsibility. And that is the final expression on an annual basis of compliance. And I believe they should see it. I wish I could, well, I'm not in the business of passing laws anymore, but I think this is internal governance good practice.
Couldn't agree with you more. We recommend that as a matter of due process, because if there's something in the T3010 which is problematic and the regulator, CRA, comes in to do an audit, that it's not adequate to say, well, a staff person made a mistake or an accountant made a mistake. At the end of the day, it's always the board that comes back.
Yes, absolutely.
I wanted to ask you, Senator, about we've talked about some of the accomplishments that you're most proud of, but tell us a little bit about some of the significant challenges that you've experienced in your efforts to help reform the charitable sector.
Oh, the challenges are many. I think the greatest challenge for someone like me who was on the outside and then became an insider is the speed of change is glacial. Things move on a timeline that is so slow, and then unexpected things happen, like Parliament dissolves. In my time, Parliament was prorogued and dissolved twice. Every time Parliament dissolves, legislation falls. It's as if it never happened. So you have to introduce it. So my bill on which removed direction and control, which you talked about earlier, I had to introduce it 2 times. And every time I introduced it, I had to think about, am I going to make it to the finish line? Is this Parliament going to survive? So that's one challenge. The other challenge is, frankly, the bureaucracy in the system, whether it's CRA, finance, or global affairs, or international development. These are the main departments that deal with many charities. The officials have been used to doing things a certain way, and their mandate is to make sure that there is no divergence from the law, and I think that is right. But that has also made them incredibly risk averse. So I'll just give you an example. The bill that you talked about, the changes in grant making to non-qualified donees. When that bill was called into law, the resistance from inside the bureaucracy was jaw-dropping. The first version of their interpretation of the bill was actually worse than the previous law that I was trying to change. So I think maybe this is the old generation of bureaucracy. We need younger people in policy. That's just generally my observation coming out of Ottawa. We need new blood. We need public officials who can protect the public good, but are also open to innovation. So, this example of the of the mentions of risk in the new guidance around grant making to non-qualified donees. And it's an example of that. I would have much preferred the guidance to have been focused on due diligence with risk as one of the factors. But instead, we have guidance that hones in on risk in such a way that I fear that it casts a chill over charities wanting to actually pursue a path that is a path of equal partnership with non-qualified donees.
Maybe I can just speak to that, Senator. Didn't have time in my presentation to go into details on it, but since you did bring it up, the focus on risk is nowhere to be found in the legislation at all. And the focus on risk, I think, reflects an overly an excessive concern that if grants can be done to unqualified donees, they're worried about grants being done to terrorist organizations, and therefore every charity, even if they got nothing to do with sort of foreign activities that want to do grants, are going to have to meet the criteria that is a very high criteria, and it's similar to the Financial Action Task Force internationally, similar to the U.S. Treasury. It's a very high standard. It's tough for charities.
Yeah, and we wanted to make it easier and accountable, equally accountable, for charities to work with non-qualified donees. Now, this path has been opened up. I encourage the sector to look at that as an option, maybe act on it. But I hope that the sector, after 2 or 3 years, will do a roll-up and an evaluation of this new path and comment on whether this has actually opened a pathway to work with non-qualified donees, especially, those non-qualified donees are working on the big social justice issues of our day, such as Indigenous groups or racialized groups. Or, I hope to see an evaluation with facts and figures and numbers and interviews before I no longer can read.
Well, that would be a logical continuation of the initiative that you took, because I can recall your speaking about the need to move away from own activities into something different, a grant process. And the legislation is actually, it's workable, but all of the extra things that need to be done are pretty onerous.
Exactly. And they're now, most charities, and I'm very familiar with the sector, will have a lawyer on board. And they're not lawyers generally who are familiar with the Income Tax Act as it applies to charities. So they maybe have a superfluous understanding of charities law. And their first reaction is, no, we can't go near it. We should not go near it. And I'm worried about that. I would love, Terry, for your organization and others to host webinars for governors of charities on due diligence and risk, et cetera, and the possibilities of pathways it opens.
And we've done that. And the reaction that we get from charities who ask, can we do it? And we say, yes, you can do it, but you do have to meet expectations, accountability requirements, and so forth.
Exactly.
They get exhausted.
Yeah.
And so as a result, they tend to go back to the old regime, the own activity.
Own activities, yeah.
Which is not what it's not what you anticipated when you took the initiative.
Yeah, but we'll see. The proof will be in the pudding, and the pudding will be the research and evaluation. I'm certainly hoping that happens.
I think that's a good approach. And to be fair to Canada Revenue Agency, they have said a number of times that their guidance is an evergreen document. And I do believe that they're open to input from the sector to try to make things more workable. So I remain hopeful that improvements can be made on that. So thank you for that, Senator. I wanted to ask you, we have a few more minutes left, 10 more minutes. I wanted to ask you about, I think you heard Bruce MacDonald talk about the issue of possible politicization of charitable status. And I just wondered if you had any thoughts in that regard, having worked in the sector and being, of course, part of the Senate.
I think this is a very troubling, I'm not going to call it a trend yet, but it's a troubling spot on the horizon. We are becoming more polarized. And I don't doubt that some of the winds from the rest of the world will hold sway or they will inevitably blow over Canada. And as things become more polarized, it's possible that charities could become a tool for certain kinds of opinions. And there are all kinds of charities. There are religious charities, there are secular charities, there are charities that support, there are pro-life and pro-choice charities. They're all charities. They've been given charitable status, to meet their charitable purpose. So now if a government comes, and that's certainly what the Liberal government has done and has issued a mandate, which has never been followed through, by the way. So let's hope it doesn't get followed through, to the Deputy Minister, that, charities that provide dishonest counseling to pregnant women should have their charitable status revoked. There's no definition of dishonest. It all is in the eyes of the beholder. I'll give you another example, and imagine when a political party of another stripe comes in and they implement regulations or legislation that goes to the other end. But there are also small ways in which charities can come into the crosshairs in a very accidental manner. I'll give you an example. The Senate Fisheries Committee, I'm not a member of the committee, did a very useful and timely report on the seal industry. Now, as we know, the seal industry is surrounded by pro-seal advocates and anti-seal hunting advocates, and many of them are charities. And the report made a recommendation that any charity that is anti the seal hunt should have their charitable status revoked. I looked at that and I just sat back, I explored, I found out that this was a stakeholder recommendation. No witnesses from charities were called, and there was this very bold, far-reaching recommendation. And I stood up in the Senate and I spoke against the recommendation and asked the Senate to consider very seriously the implications of such a recommendation as a precedent-setting one. And I think they took note. A Senate report doesn't necessarily get acted on, but there is a legislator somewhere who will pick that up maybe and table legislation. And then all balance is thrown off course. So I think this is a very dangerous trend, and one that charities themselves should fight against.
No matter what the issue is, it's negatively impacting all charities, all Canadians. And thank you, Senator, for speaking up in that regard. That was very important for you to do that. So thank you. I wanted to ask you what you're looking forward to for the charitable sector coming up, and how can charities best be prepared?
Well, I think I listened to Bruce when he was talking on your webinar, and I think he's much more in the know about what charities are facing. But broadly speaking, I would be worried about AI and how it can destabilize charities. I believe the charitable sector should set up a task force, maybe under the CRA, to determine how best to use AI, what guardrails the sector requires, whether these are in internal governance policies of the sector or of an organization or the sector at large, or whether they actually need to be part of some legislative endeavor. I don't know, but I think don't let it happen to us. That's my fear. We're sitting back and letting it happen to us. We need to be proactive. So I certainly hope that the people who are listening to the webinar will take this call seriously. Perhaps something is already happening. Throw in cybersecurity. You know, we're facing some real threats. I look at what's happening to charities outside Canada in the world. Charities are being weaponized as political tools of a government's agenda. This, we should guard ourselves against those trends. And of course, there are the operational issues that every charity is facing: less money, more demand, more competition, a retiring senior workforce, absence of succession planning, no real HR capacity. So I think about all these things, and I'm generally an optimistic person. So let me turn the question to you, Terry. What are you optimistic about?
I never get asked the question, but thank you for asking.
It's a fireside chat after all.
Well, thank you. I am an optimist from the standpoint of charities providing an opportunity to have a passion for a purpose. Instead of looking at ourselves or looking at profit or the person, the greater good is accomplished through charitable purpose and through nonprofit organization. I think it's the hallmark of what we are as Canadians, that we come together and be able to do something for our neighbors, for our community, for the people that we don't normally come in contact with, but don't have as much as we do. And we can help what the food banks do in our communities, what we're able to do internationally. That reflects the best of what we are as Canadians. And I think we should be celebrating and supporting what we do as charities in the nonprofit sector. And so I'm very optimistic that the passion for the purpose is going to prevail over anything else that could be a detriment to Canadian society. That's who we are as Canadians. And Senator, thank you so much for being a leader in the charitable sector, in the nonprofit sector. You've made a huge difference for good.
Thank you, Terry.
And wonderful to have you on for our fireside chat. And we will, even though you're retired from the Senate, you're still active. I think you've got some things lined up at the Toronto Metropolitan University. So
yes,
we will be keeping in contact with you and looking for further insight from you. Thank you.
Absolutely. Look forward to that as well.
Well, thank you, Senator. I think this is probably a good transition point. And we're going to thank you again for being part of it. And then we're going to move over to the Q&A time that we have at the end. Thank you again, Senator Omidvar, for being with us.
Thank you, Terry.
Okay, so I think we should have all the speakers up, hopefully. Someone can give me some feedback. Are we good with all the speakers? Okay. I will assume no news is good news. Oh, there we are. I can see in the control room. Thank you very much, Mike. Mike Dawson is doing a great job with Event Stream, keeping us on the straight and narrow. So we have 15 minutes, and I want to just go through some questions for each of the different presentations. In no particular order, I'm going to start with you, Esther O. and Urshida. If a charity has 3 directors, can it pay one of its 3 directors to provide services at less than fair market value to the charity?
Sure, I can take that one. Sorry.
Okay.
That would be great.
Yeah, okay. So the answer is no, because the regulation requires at least 4 directors who are eligible to vote on the payment, which would exclude the director receiving the payment. In addition, even if the charity did have at least 4 voting directors as required, other requirements as set out in the regulation and guidance must also be met.
Okay, thank you very much, Urshida. Then over to Jackie and Ryan. Are same protocols required when a charity is giving a gift instead of receiving one, e.g., gift to an educational institute for student scholarship program? So are the same protocols required when a charity is giving a gift instead of receiving a gift? So it's kind of ties into a little bit what we talked about in my presentation, but turn over to you, Ryan or Jackie.
Ryan, do you want to go with it?
Sure. So I would say no. It's more so the presentation that Jack and I were doing this morning were around wanting to have a written policy that deals with when the charity is going to be receiving gifts and different types of gifts, and how it wants those. It sounds like the question is more concerned with, the organization might be some kind of foundation, or it might be a church or another organization that typically might want to provide a number of gifts to different qualified donees or registered charities during the year. So in that case, the documentation you would need would be a bit different. You would still want a gift agreement, as Jackie talked about, and a lot of the considerations that would apply when a donor is making a gift to a charity would continue to apply when a charity is making a gift to another charity, especially for a particular purpose. But in terms of the policies around that, you would have quite different ones that deal with whether or not the recipient is a charity that fits within the scope of the purposes of the foundation or charity making the gift, and different things of that nature. So, you'd still want some kind of policy or documentation in that regard, but it would be covering quite different things.
Okay, thanks, Ryan. For Esther, Shaneblum, and Cameron, here's a question. Given the risks associated with IT policies and cybersecurity, do you recommend that any board discussions on cybersecurity issues be held in camera, particularly if your organizations normally publicly post your minutes of board material or your minutes or board materials? Which maybe, Esther, do you want to take that one?
Sure. Firstly, there is no need to make board minutes public, and so I would reconsider that policy position that you're taking. Generally, it's considered to be confidential and not to be released to the public. So, just as a general principle, that would be my first comment. And secondly, not really. I think in-camera meetings should be reserved for, unless there's a huge risk issue that's arisen out of your IT policy, like risk of litigation or some sort of, conflict of interest or pending insolvency or something like that. Generally, major decisions should be made at the, on the minutes with the full board present and with the minutes recording the decisions you've made and why. Because as we were talking about in the presentation, you have to demonstrate due diligence. So if everything's off, to the side and you're not recording those minutes in the regular minutes of the board, at least not for the short term, I don't think that would necessarily achieve what you're looking for in terms of demonstrating due diligence.
Okay, thanks, Esther. So over to Sean and Heidi. I once heard that it's important to delete all documents we're not required to keep according to law, because if we are faced with an audit lawsuit, we could be ordered to share everything in our files on our computers. Is this true?
That's a very interesting question, actually. So, a charity could take the position that they would want to shred everything as they go along, but you're taking a risk, because when the litigation comes up, when CRA comes to call, you want to have that narrative there. You want to have that substantive piece of paper, that correspondence that backs you up. So if you are deleting it, you're running a risk. And not only that, there is a positive obligation under the rules of civil procedure that as soon as there is even a threat of litigation or even a possibility of litigation, you must preserve all potential evidence, or else a negative inference will be drawn against you. So that's extremely important to remember. So if you are into that shredding stuff, if you ever get the hint of a litigation, stop right away, because that's a very dangerous position to continue, especially with the threat of litigation.
Okay, and just to add, for charity, of course, they have record-keeping requirements depending upon the particular documentation for a number of years. But good idea to keep the documents available so that you can raise a defense or an explanation. So thank you for that, Sean. Barry and Martin. So what is the alternative of offering a fixed term contract? What's the alternative?
Maybe I'll speak to that, Martin.
Okay.
Well, the most common contract in employment situations is actually an indefinite term contract, where an employee is hired not for a specific fixed term, but on an indefinite basis, and with termination rights as set out in the contract. Fixed term contracts should typically only be used for relatively short terms. I would recommend not more than a year or 18 months in some cases, typically for people on specific tasks that will be done within a certain amount of time, or to replace someone who was on a job protected leave of absence, such as a sick leave or a um, um, parental leave or a pregnancy leave.
Thank you, Barry. Teresa, some questions about donor advised funds. Here's a question. How are donor advised funds different from externally restricted funds? Question mark. Are the restrictions not advised? In other words, is the donor advised aspect not a restricted fund? So Teresa, your thoughts?
The great question. The short answer is look at Jackie's PowerPoint, and in her PowerPoint, there's a paper attached to it. But very briefly, a donor advised funds is a fund that is set up that would give the donor the ability to give non-binding advice on how to use the fund. So it may or may not be restricted. It may be wide open, and then the donor would be able to provide non-binding advice on how to use the fund on the various programs of the charity, no restriction. But a restricted fund is where a gift is made by a donor, and at the time when the gift was made, the donor actually imposed restrictions on how the gift may be used, in terms of time, management. So that would be an externally restricted fund. Restricted funds can also be internally restricted by the board. So it's a very interesting question, very complicated legal issues attached to those, what they are.
Okay, thanks, Teresa. Question for my presentation. Where does the flow through fit in the non-qualified donee options? So full context for the question, but you want to ensure that the charity is not simply receiving funds to act as a conduit over to a non-qualified donee. The charity has to be in control of what it does. It can perform programs and activities through an unqualified donee with the different options we talked about, but the control must be with the charity and its board, not with the donor, to kind of flow through and use the charitable status of the charity to get a receipt, only to have it go over to the intended non-qualified donee. So I wanted to go back. I think we covered everyone with one question. So this is over for you, Jackie, dealing with your presentation. Can an amendment clause give a charity full authority to change the purpose of a gift and not make it align with the original spirit and intent of the gift?
It really is going to depend on what the gift agreement says. If that's specifically contemplated and authorized by the donor at the outset, then it would be possible, but that's not normally what would go into agreements of this nature or the ones that I draft. Normally, the focus is on finding something as near as possible to the original purpose. That's what our variation clauses generally say. But conceptually, if it's clearly written in the gift agreement that that's possible, and provided that the change purpose fits within the charity's general charitable purposes, it's conceivably possible.
Yeah. Okay, thanks, Jackie. Then over to you, Cameron, and Esther. Maybe this one for you, Cameron. what are specific examples of risk in the field of IT governance and data management? You mentioned some of them in your presentation, but are there some specific examples? I think the individual is asking the question.
Yeah, so there's a large number of risks. One of the big ones that we talked about that was involved in the 2017 Equifax issue was, I believe they were hacked, and they were hacked because their software was not up to date. There was a patch that was available for their security software that it was, with the IT department, they just hadn't taken the steps to actually install this patch. And because of that, they lost the data of over 100 million people. So you're vulnerable to risks when your software isn't up to date and when your IT governance policy does not ensure that you're keeping on top of these evolving softwares. Like when these products are constantly changing to deal with these evolving risks, you need to absolutely ensure that you're always on top of that.
Great. Okay, thanks, Cameron. And over to Heidi, you and Sean. Here's a question. If an email or other communication that is covered by solicitor-client privilege is sent by accident to an incorrect party outside of the solicitor-client privilege, what, if anything, can be done to try and continue to preserve privilege?
Sure, I'm happy to take that one, Sean, if that's okay. So this does happen. Obviously, we get in these situations where we're typing email addresses really quickly into our email provider, and you type in John and it goes to the wrong John, or perhaps someone's just looped in on an email when they weren't intended to be. And of course, we really want to avoid a situation of inadvertent waiver of particularly solicitor-client privilege. So there are some few steps that you can take, hopefully, to try to continue to preserve that privilege despite having sent it truly by accident. Just what you would do is reach out to the person who received it by accident and say, don't open this email. Please delete it from your inbox and delete it from your deleted folder as well. So you can ensure that the person actually hasn't read it and no information has actually been shared. But it's really important to try to just do this as proactively as possible. As soon as you notice that this has happened, jump on it right away. Do not wait, because the longer you wait, the more exposure you might have to, as I said, this inadvertent waiver of solicitor-client privilege.
Super. Thank you, Heidi. Teresa, and we got time for two more questions. So Teresa, and then follow up with Esther and Rashida. Teresa, our church has about 30 directors. Wow. In our T3010 return, section B, we usually list only 5 directors with positions such as president, vice president, secretary, treasurer, accountant, etc. Others are not listed. Is that okay?
Short answer is probably not. If you truly have 30 directors on the board, which is a huge board, then yes, you need to list all 30. It's asking for all directors, not asking for officers.
Right. Okay. And then last question for Esther, if I could, because I think Rashida answered the other one.
Yes.
Are all payments to directors and connected persons allowed under the regulation and guidance, as long as the board determine it's in the charity's best interest and the payments are less than fair market value?
So the answer to that question would be no. The regulation and guidance are very clear that there are certain circumstances that a board cannot authorize a payment to a director or a connected person. A couple examples were in the slide, but one is like you can never pay a director to serve as a director or a director to be an employee under the regulation. And in those cases, you would need to get a court order or a consent order from the PGT.
Great. Well, thank you. And that wraps up our questions. And now we're coming kind of to the end. We did say 1 o'clock, but we do have some door prizes, which we want to remember. And Sepal, if you want to stay on with me on this and make sure that we've covered it. Sepal, could you do the thank yous on the if that's possible?
Sure. Yes, of course, of course. So, first and foremost, of course, we want to thank our entire team. A lot of work goes into this day on the back end, and the presenters and everybody. So, thank you so much to all of our speakers: Sean, Heidi, Barry, Martin, Jackie, Ryan, Terry, of course, Esther, Cameron, Teresa, Esther O, and Arshita. Thank you so much. To our special guests, of course, the Honourable Ratna Omidvar, thank you very, very much for your informative discussion today. Also to Bruce MacDonald, President and CEO of Imagine Canada, thank you. We've got a big back-end support team that helps us out. Willow Brown, Bridget Bird, Adriana Ferreira, Lauren Haythorne, Monica Keller, Jennifer Kirkhow, all members of our team that, are really kind of flexing back there that nobody gets to see. Also, Brenda Parsons, Sunil Patel, Bruce Phillips, Wendy Speziality. Thank you very much from the management side of Carter's. And lastly, thank you so much to Mike Dawson at EventStream, who's been kind of tirelessly working with us over the last, weeks to get everything moving smoothly. Also, a big thank you to our sponsors: Adams and Miles, Robertson Hall Insurance, Thomson Reuters, LexisNexis, and Beacon Endowment Solutions. Much appreciated.
Wonderful. And Sipal, do you want to announce the door prizes? And I will be your assistant and hold them up.
Perfect. Thank you, Terry. Okay, so now the moment you have all been waiting for, the door prizes. So the first one, thank you, Terry, the winner of the Thomson Reuters Corporate and Practice Manual for Charitable and Not-for-Profit Corporations, which is a 3-volume set, goes to Joanne Kostopoulos. Joanne Kostopoulos. Congratulations. Okay, so next we have LexisNexis 2025 Charities, Legislation, and Commentary. This one is actually hot off the press next month. So the winner for that is Mike Helder. So Mike Helder, congratulations. Next, we have the Management of Not-for-Profit and Charitable Organizations in Canada, 5th edition. And the winner for that one is Karen Felker. Karen Felker. Lastly, my favorite book, Branding and Copyright for Charities and Not-for-Profit Organizations, the 3rd edition. And the winner for that one is Bailey Coultier. Bailey Coultier. So I hope you enjoy that one, Bailey. You'll have to let me know. And lastly, the $100 gift card for the 4Cs store. The winner for that is John Sully. John Sully. So congratulations to all the winners. You'll hear from our team regarding how you can claim your prize. And lastly, I just want to take a moment to thank you, Terry. For decades, Terry has advocated for the sector and worked tirelessly to provide information and advice to charities and not-for-profits. And I know our firm, our clients, and the audience really appreciate all that you do. And I will have you know, I'm seeing some comments from people that are actually requesting copies of your jokes. So you could always go on the road as a comedian.
Good. Very good. And thank you for those kind comments, people. It was great to have you as a co-host. It makes it so much more fun, and we just had a great time together. We're going to be booking a time in November next year, so we'll send out information about that. Thank you very much for everyone staying on to the end, and we really enjoyed ourselves today, and I hope that you enjoyed the presentations. Don't forget the evaluation form. It's really important. We read it very carefully. So please fill it out. Tell us what we're doing right, what we're doing wrong. We listen and try to adjust accordingly. Thanks very much, everyone. See you later. Bye-bye.
Bye.